The February 10th, 2026 work session of the Anne Arundel County Council is called to order. Please ensure all electronic devices are in silent mode. Do any of my colleagues have any questions before we begin? Seeing none. All right, we will get started with Bill number 826, Board of Education Supplementary Appropriation and Transfer of Funds. Mr. Hunt.
Thank you, Ethan Hunt, for the administration. I'll have Kelly Kenny, our supervising county attorney, Matt Stansky, the director of finance from Anne Arundel County Public Schools, and Chris Trumbauer, our budget officer, is in the audience as well. Okay, fair enough. So this is a legislation introduced on behalf of the Board of Ed, making fund transfers and supplementary appropriations from unanticipated revenues to the local education fund for this fiscal year. It recognizes $6,412,762, an increase in revenue from federal, state, and local sources, specifically $2,190,000 in federal, state, and local restricted funds. It appropriates $4,222,762 in unappropriated fund balance and reallocates $1,172,800 among Board of Education expenditure categories. The Board of Ed approved this request at its business meeting on December 17th, 2025, and I can turn it over to Mr. Stansky if he wants to add any more details.
Stansky, Chief Financial Officer for AACPS, and no, that was a great summary, and happy to answer any questions the council has.
I have a question, Mr. Stansky. Are we on target to receive all of the federal funds that we had planned for FY26?
Yeah, we are.
Okay,
yes.
Good. So nothing's been held back or cut?
No, overall, we saw a reduction in our appropriation levels, but yes, payments are coming in.
Okay, great. All right. Any other questions? Mr. Volke, any questions? Not yet. This is the Board of Education transfer.
26, I heard.
Okay. All right.
We're good.
Okay. I think that's it. Thank you, Mr. Stansky.
Thank you.
All right. Next is Bill number 926, zoning battery energy storage systems. This is yours, Ms. Fiedler.
Thank you, Madam Chair. The bill is pretty self-explanatory. It adds a use to the use chart. I know that there are some concerns, or not really concerns, but preferences or questions of the administration that I'm working to answer and or address. So I feel like we're working through this, but I'm happy to answer any questions if you have them.
Okay. Administration.
Thank you, Ethan Hunt, for the administration. I have Lynn Miller, our Assistant Planning and Zoning Officer, Kelly Kenny, our Supervising County Attorney, and Captain Donna McGuire, the Bureau Commander from the Fire Department, who can answer questions about the fire code as it relates to this bill. So I appreciate the sponsors' comments. We have been exchanging emails and shared some feedback from Office of Planning and Zoning on a couple points to address in the bill. I think two other things I would add just from the fire department, and these are simply minor things that can be added, I think, is one, requiring installation of a fire department approved Knox box entry system, which I'm sure the fire department can explain what that is because I cannot. And that's for the secured gates, doors, and emergency control points so that first responders can get access to the site if needed. And then requiring maintenance with National Fire Protection Association standards and a written emergency response plan with site-specific training for emergency personnel.
Yeah, I think that that's all reasonable. And I'm here, but my computer wasn't here just yet, so now I can talk a little more that it's awake. This bill was really brought about as an alternative to store energy in close proximity to where energy is traditionally stored. Should there be a massive cutoff from traditional sources, there is stored energy that then can be sold back to the consumer. And again, close proximity to an already existing energy facility. And I think that there's definitely a willingness on my part to add those. And I think in knock boxes, it allows the fire department to access when there is a locking mechanism. You would have a code or something, correct? Is that what that is? Yes.
Does the fire department have any outside of the normal, just like you said, for a plan? Are there any fire concerns about a facility like this?
No, ma'am.
Not anything, just the regular, let's have an emergency plan and a way to
Emergency
get on it?
plan would include the vegetation maintenance would be our biggest concern.
Okay. Ms. Schultz, can I be added on this one as a co-sponsor, please?
Yes, Madam Chair, thank you.
Thank you. Ms. Rodbian?
Thank you. I'm actually curious because I know, battery fires have developed a reputation for themselves. So what is the method for extinguishing a battery fire? I'm actually, but just to be clear, I fully intend to support this. But I'm just curious how it works. And it sounds like if the fire department is comfortable with this, then I'm comfortable with it. But I just would like to learn a little more.
Sure. Captain McGuire, Fire Marshal's office. Copious amounts of water is the where we're at right now to fight these. Unfortunately, there's not an extinguishing agent available for such a large battery, so it's just copious amounts of water. You would see all over the United States they'll bring in dumpsters and fill it with water, then drop the batteries in it, and then wait a couple days.
So even in a like completely submerged in water, a battery could continue to burn?
While it's losing its charge, while it's in the water.
Okay. Oh, so that would like prevent further.
Yes, ma'am.
And then if you took it out, then it would like reignite?
Well, after a few days, we should be good to go.
Right, but if you did that before a few days?
Potentially, yes.
Okay.
And it's happened, yes.
So would part of the, emergency plan include having, I don't know, dumpsters? Is that what you described? Dumpsters full of water on site, or?
I would say
like
that our
tanks of-
operations bureau would have a plan in place as far as, make sure that we could bring copious amounts of water to wherever those battery storage places are.
So tanks on site wouldn't necessarily be necessary, like just to have them
Correct.
there in case of an accident?
Not necessary.
Okay, well, thank you.
You're welcome.
Still a little like, I don't know. I know actually one of the things I just learned about when I traveled to study, sustainable technology, about boats that are used, that have battery power, that are battery powered, is that the best method is just to let them sink, like to get all the passengers off board and let the boat sink. So it is interesting. I hope there's improved technology because with respect to batteries, I feel like there's a lot of so much good that can be done environmentally, but obviously that's, a concern. So thank you.
Mr. Volkey?
Thank you. Where does this come from? Who's asking for this?
There is a company that's actually paying very close attention to the energy status across the country, and would like to locate in Maryland to provide additional energy supports and backups. And there is it's not a use that's in our code.
Yeah, I see. Why an RA?
I think because RA allows for, that's not a question that came up in our conversation, but I would imagine that it allows for the space with RA being not intensified residential dwelling. If that's a concern.
My concern is the water. You're going to put these in RA, but that's the place where we probably have the least water. So
Okay.
I think the challenge that I would see, and you can tell me from a fire standpoint, but my understanding is RA, you're probably not on public water and sewer. So you're either pulling from a draft tank or you're having to bring water on site, which then we're talking about copious amounts of water to put out a battery fire. And we're kind of in a place that has limited water resources already.
Yeah,
So
that's a
I
valid
think
argument.
RA to me is a concern. And then, you have this, I have this, but down peninsulas, I definitely have C1, C2, C3 down peninsulas, which is going to have the same type of water concerns. So if there was a way to maybe limit the battery energy storage systems not on peninsulas, I think that would be helpful too. I don't know that they'd want to go on peninsulas, but I'm just thinking about that, trying to consider where it's going to be safest.
So I think there's definitely a way to add language to address the concern without saying peninsulas, because what we've learned over the last 7 years is that Anne Arundel County itself is a peninsula. So that term gets a little bit into a sticky wicket situation, but I hear that. I hear what you're saying, and I certainly don't want to have unintended consequences. So
Yeah.
I'll revisit that section.
All right. Thank you.
Ms. Pickard?
Thank you. I'd also like to be added as a co-sponsor. I will say I've had a briefing from BG&E on this exact issue. Of course, they didn't think they needed any legislation. I had to correct them on that. But is the administration currently in communication with BG&E about these?
I can follow up.
I believe I've had a conversation with Ms. Dempsey about it. But it sounds like the private sector is moving a little faster than.
Mr. Smith?
So this, obviously a couple months ago, we passed a resolution discussing energy needs, and this certainly aligns with the long-term plan of facilitating a infrastructure that can sustain alternative energy sources in the future. So I certainly think this is a wise idea. I was looking at when we brought up the peninsula issues. If you look at, because these are in there as condition, and so I think having that mile away or within a mile of an existing substation, the 2.5 miles from critical areas, that pretty much knocks out the peninsulas right there, because a lot of the peninsulas are adjacent to critical areas. Vehicular access. So I do like some of the conditions in here, and I think we can probably add to that to address any other concerns. I say that because I certainly want it to be added as a co-sponsor as we build out our infrastructure for sustaining our own energy needs here in Anne Arundel County. This just aligns itself with doing that. So, thank you.
Ms. Rodman?
Thank you. This may be a question remind me your name again.
Donna McGuire.
Don McGuire. Thank you. Appreciate it. And you're fire marshal.
Yes, ma'am.
Okay, thank you. Do you have any idea of the cost of, I know in places, I know there are spots in my district that have underground water tanks. Do you have any idea like what the cost of those, and would that be something that might be, a way to kind of help quell the concerns? No pun intended.
I don't know the cost of them. I know that the county is only allowing, used to be 5,000 gallon underground tanks minimal, and that was changed to 15,000, our last code amendment. So a lot of the tanks that are already in the ground down there are only 5,000 gallons. Unless they're new, they could be 15 or 30. But with the thing with the underground tank is it doesn't refill on its own, so we would have to bring water to refill it on its own. I think there's only one in the county that actually does refill on its own. But I don't know the cost, okay. And they're probably anywhere between 5,000 and 15,000 gallons of water.
Okay. And I have a question maybe for the sponsor and then maybe to come back to you. Do you know the size of the batteries themselves, or like, I know that when I met with, the individuals that are pursuing this, they kind of showed me, what the facility looks like. But I'm just curious if you happen to know what the batteries themselves are like, or the size or anything like that.
I haven't seen a picture of an individual battery, just the areas that they would be stored. I would imagine they're rather large, larger than we would see in a landscaping tool or something like that.
Oh gosh, yeah.
Yeah. They're not tiny. I would imagine they're not, but no, I haven't seen an actual picture of an individual battery.
Okay. And then I guess this is maybe a question back to you. Usually, like if you have a sort of a series of batteries working together, I mean, unless there's a pretty good distance, if one were to ignite, you're very likely going to have like the whole series ignite. Is that fair to say?
That's fair to say, yes, ma'am.
So I'm just wondering if maybe a requirement to have, like, yes, it's true you would, obviously they're tanks, they'd have to be refilled, but hopefully you would never actually have to refill them because we wouldn't have a fire and it would just be there and you could check and make sure that it hadn't like leaked out or, I don't know, something like that that wouldn't be an ongoing concern. But would that be something, do you feel like that's necessary, or do you feel like there's, because I have a feeling that this is just what we know about, this whole industry, it's pretty profitable. And so, suggesting something like that for someone who wants to undertake this, which I think is a good thing. We definitely have energy issues. And, my understanding is that bringing the storage closer to the source of use can help bring down the cost and, allow storage for, sort of off-peak hours to be used during more peak hours. I don't know, do you feel like that's something that would be helpful or necessary, or do you, of course, I don't want to ask if the fire department is confident that they could bring water, of course you are, but would it be even maybe a step better to have like storage tanks, like water storage tanks on site?
Tough one for me to comment on. I mean, obviously, more water is better for everyone, not only that site, but any of the homeowners that live right next door, right?
Yeah.
But I think that I would be more comfortable commenting after I saw like what the site development plan would look like.
Okay. Is that something that we could maybe add as, if maybe it doesn't need to be in the bill, but if the fire marshal, like give you the discretion to say, we know where the sources are nearby, and we know, we have at least an idea of how much water, I mean, copious is, is a lot, but we know what the nearby sources of water are, and once you have a site chosen, could we give the discretion to the fire marshal to require underground storage? I mean, would that, maybe give you a little more leeway to, to make sure that the fire suppression resources are in the right place should there be an emergency? Like, could that be part of the emergency plan maybe? Would that be allowed?
I would say if we were listed as a reviewer during the permit process, then we can absolutely make those comments if we were listed as a reviewer.
Okay. Would that be, I guess now this is a question for Office of Law, would that need to be in the legislation itself?
Kelly County Supervising County Attorney. I think all of these would go through the site development plan process, and so fire would automatically be a reviewer for that, and they would review for adequate fire suppression, right?
Okay, so wouldn't necessarily need to be in the legislation. Right. Obviously, like I've supported several pieces of legislation that rely on battery technology, and I want it to be successful. And I think it can be successful if people feel that, if they know that they're really protected. And I know this is a big concern about, even I think like the electric car battery is like, about that big. So I'm imagining it's probably significantly bigger than that. And that, that's whether rational or not, although I think there's always at least some, it's always somewhat rational, but we'll just make people feel safer if they know that these things are in place. And if the fire marshal, I really I'm saying this because I want this to succeed. I think this is something in terms of energy that is really valuable and helpful. So if that can be something that the fire marshal has the discretion to require in the process, I'm all for it. So I think my questions have been answered. Thank you.
Mr. Volkin.
Hi. Quick question for you. Toward the end of the bill, there's a line that says expedited review for certain projects. OPZ shall expedite the review and approval of SDPs and permits for facilities that meet all the requirements of this section. Question for OPZ. Is this something we normally include in legislation?
Lynn Miller, Planning and Zoning. No, not typically, and we did actually offer a comment to the sponsor with some concerns about that. So
what was your comment and concern?
is that it was difficult for OPC to pull out specific types of applications and prioritize them over others.
Okay. And so just sort of looking at this, what does this mean in terms of the practical effect of like, if we put this in the legislation, what does that mean in terms of the review time? How much faster is it?
I don't think it would have much practical effect because it doesn't have any specific parameters. And again, we take applications in the order that they come in, and we make every effort to expedite all of them to the extent that we can.
Okay. Do you all want this language in here, or would you prefer this to be out?
We would prefer it to be out.
Okay. All right. Thank you.
I was thinking we could add it to
Everything.
We expedite everything. I don't know.
So-
be our new line in every bill in the code. Obviously, we know that Maryland and Anne Arundel County is losing out to our neighboring states, and expedited review and barriers to is a problem for our economy. So. I mean, it's struggle is real.
Ms. Fiedler.
Thank you, Madam Chair. So that language was added for that very reason, because it takes, if you talk to stakeholders in the industry, it takes Anne Arundel County almost twice as long to get through the review process than any other jurisdiction in the state. And time means cost. Whether it be commercial or residential, it means cost, and that gets passed to the consumer. But if we're talking about the potential for a review process that takes 6 years, the energy crisis situation in the state of Maryland is not going to get better in 6 years. I would suggest that it may get worse. So that is why that language is in there, because time is of the essence. But I do appreciate the question. And I do want to add that at the end of the bill, with regard to concern about fire issues, there is a requirement that prior to the issuance of the permit, conduct a hazard mitigation analysis as specified by the NFPA, which is the National Fire Protection Association. So there is language in there to make sure that those concerns are reviewed before the permit is issued.
Ms. Rockby.
Thank you. This is a slight tangent, but I don't think it's, hopefully my colleagues will see why this is still helpful, even though it's a slight tangent. My understanding is that the administration has been working on, there's some sort of work group looking at the processes of inspections and permits. Is that correct?
I believe it's been an ongoing topic of discussion. I'm not sure about a specific work group, but it's a constant source of something we're examining.
Okay.
Yep.
No more, I don't know, is that all? I mean, there's no more detail than that, so there's not.
I don't have
There's not
anything more
something
right now, but I
specific.
can
Okay.
certainly circle back.
Okay, thank you.
All right.
have
Any
one more
other
question.
Yes, Mr. Fulton.
Thank you. Are you aware in the Public Utilities Code, this might be a Ms. Kenny question, sorry, I'm looking it up myself at the same time because I was just providing this information, that expedited review is required for these types of projects under the Public Utilities Code, Section 7-219 F2. I'm trying to pull it up as we speak, but I just didn't know if anybody had looked at that.
No, I was not aware of that, but I can take a look. I know there's something like that in the law with regard to solar facilities, and it has a specific number of days for review, so I'll take a look at that. You said
Okay.
public utilities, right?
Yeah, it looks like it's Public Utilities 7-219. Because
Okay.
then I guess the question would be, if state law provides a period in which expedited review has to happen, then if we put in the expedited review, well, candidly, whether we put it in or not, state law would dictate, it sounds like.
Right, depending on how it's worded.
Yeah, I'm looking right now. So 7-219 of the Public Utilities is front of the meter energy storage devices construction approval local authority. And in subsection F2, a local jurisdiction may not adopt laws or rules that prohibit the construction or operation of the front of the meter energy storage devices or deny site development plans for front of the meter. Subsection 2, a local jurisdiction shall expedite the review and approval of site development plans for front of the meter energy storage devices if those plans meet the requirements of this section. Adopt standards processes for the review. Okay.
I don't know what front of the meter.
I don't either.
I don't. That doesn't
doesn't
sound like
feel
a
like
battery
this.
storage
Right,
facility.
right.
That sounds like something like on your, utility meter or something like that.
You know, we would hope that the state defined it somewhere.
Yeah, I could look at that and get back to
Okay.
everybody.
All right. Well, yeah, if we could get some information on that, I think that might be helpful. Thank you.
All right. Thank you very much. We'll now move on to Bill number 1026. Thank you, Ms. McGuire, for coming in. This is regarding Police Accountability Board. This is my bill. Currently, the Police Accountability Board requires that its members do a ride-along with the Anne Arundel County Police once a year. This just expands it so that it can be with any of the law enforcement agencies, not just Anne Arundel County Police. It would be Crofton, Annapolis, Community College. That's everyone, right? So,
And Sheriff, yep.
Mr. Hunt?
Thank you, Madam Chair. Ethan Hunt for the administration. I have Kelly Kenny, our supervising county attorney. This was, I appreciate the sponsor putting this bill in. This was a request of the Police Accountability Board. You remember a few years ago when we were implementing the Maryland Police Accountability Act locally, we had a pretty extensive list of training requirements that all members of the PAB were required to undergo. One of those requirements was an annual ride-along with the Anne Arundel County Police Department. However, since the PAB works with all the law enforcement jurisdictions, agencies in the county, so that's the Sheriff's Department, Crofton Police, Anne Arundel County Community College, and Annapolis Police, they've asked to have that requirement include all the departments so that they can do ride-alongs with the various agencies. So that's all. Happy to answer any questions.
Any questions? All right. We'll move along. Bill number 1126, Recreation Parks, Article 14, Code Revision. Mr. Hunt.
Thank you. Ethan Hunt again for the administration, and Kelly Kenny, our supervising county attorney. Joining me, I'll have Erica Matthews, our deputy director for the Department of Recreation and Parks, and Chris Carroll, our parks administrator for the department. So this legislation was introduced on behalf of the Department of Recreation and Parks. It updates and modernizes Article 14, which is the section of the county code that covers recreation and parks. If you look at it, Article 14 is actually quite short, but this bill will align definitions with current state law, especially as it regards to electric bikes, scooters, and drones. It has some stricter environmental protections, such as prohibiting release of balloons and use of confetti or glitter in parks, while also refining public safety rules for swimming, golfing, and shoreline mooring. Improves operational efficiency by providing for digital public notice requirements and updates the permitting process for organized gatherings. Also clarifies the park director's authority to manage commercial activity within the park and enforces pack-out trash policies in order to protect and preserve our public lands. I can turn it over to the department if they have any additional comments, and we're happy to answer any questions.
Hi, good morning. All right, this, page 5, subsection 14-1-106, director's discretion. This appears to be codifying what I understand has been existing practice, right? Which is that the director has historically had the ability to sort of make decisions for how certain programs are run in the parks. Is that fair?
Good morning, Erica Matthews, Deputy Director for Recreation and Parks. Yes.
Okay. So going to the next subsection, 14-2-101. So the alcoholic beverages, I'm sure you all will remember, in my district, we've had certain parks where there have been user groups that do activities that have served alcohol. And historically, they've been granted permission to be able to have the alcohol on site, provided that they get a license from the liquor board, and then they are operating the event. And basically, there are no issues. I don't think there have been issues in the past, but this seems to me like this is going to completely exclude that from even being something the director could allow. Is that right?
Erica Matthews, Deputy Director for Recreation and Parks. The use of alcohol has always been somewhat prohibited in the park. We have allowed it in certain locations like wedding venues, and when the director gives that level of discretion. That discretion is still there. It's just in a different section, so they would just come in, submit the same information that they've been requesting. We would review whether or not there are any additional licenses that would be required, and then we would issue the permit. Again, the goal is to not exclude participation in the parks, but to sort of make sure that there's peaceful enjoyment of everyone in the parks. So as long, that's always first. And then this application, they turn it in, we process it, and they would get a response.
Okay. And I guess the concern that I have with it is this. I know that under previous administrations, the allowance of alcohol at events in parks, and the one that I'm talking about, just to be clear, is Bodkin Park, where historically they've done a softball fundraiser down there. And in doing that, they've had alcohol at that event before. And that's historically been allowed. But over the past couple of years, it's been tougher and tougher for them to get that allowance. So the concern I have with this is, by putting all of this discretion entirely in the director and knowing that historically this was allowed, but then that's changed over the last couple of years, the concern I have is by sort of making this the way that we're going to make it, and the change here where we're deleting this unless as part of a group having permission for exclusive use of the park, which is kind of their exact situation, it takes away some of the ability for them to argue, hey, this makes sense for us because we're the only ones using Bodkin Park on this date at this time, because really nobody else is going there. This isn't like they're going to a regional park where, there's lots of other users there. And it feels like it puts all the discretion into the director's office, which may or may not support that use. And I think they've had a little bit of difficulty with that the past couple of years. So that's my concern with this.
I think you hit the key part of it.
Yeah,
is
go
the
ahead.
exclusive use of the park.
Yeah.
So because an organization has rented use of a field or a pavilion, they don't have exclusive use of the park. So where it becomes a challenge is if we have someone else in the park, or the rangers have to come and enforce, it's not exclusive. So I think that's the key word is why this has been changed.
Okay. So have you had a lot of problems with that, where you've had people who have felt like they've not been able to get in the park because the user group has excluded them? Or are you feeling like this is something where you've had the rangers have to step up and do overtime in terms of enforcement? Like, I'm just trying to understand what the impetus is for this.
Yes, I'm going to ask Chris
Yeah,
Carroll, who's
please.
the Chief of Park Administration, to answer the operations impact.
Good morning, Chris Carroll, Parks Administration, Recreation and Parks. I receive probably each year about 30 specialized permits that we work in partnership with our athletic side of the house. So they come in, if they're renting a field, if they're renting an athletic area, it goes to our athletic sides and then comes over to my side for review. I would say each year, to answer your question, maybe about 4 or 5 request the alcohol permit. In most cases, those have been granted. There are a few who have not. And one of the things in Article 14 is the kind of avoiding the public perception that an entire park is taken over by a group. So we look at each and every single one of those on an individual basis, and by and large, I'd say we've only had about 4 each year in terms of requesting alcohol usage and whether there was any controversy. So it's not a large issue that comes across my desk.
Okay, so when you say it's a controversy, can you detail for me what specifically is the controversy? Like, do you have people who are not with the user group who are complaining, this feels unfair, this user group has taken over this park? Is that the complaint you're getting?
Maybe once or twice a year, some of the athletic groups feel that a lot of the parking's taken over. We've had a few instances where we have athletic and sports events going on at the same time that a group's requested, where we've had the rangers go out to have to try to balance out that use. But again, out of probably the 50 of those events we have, there's not a significant amount of controversy or any problems.
Okay, and that's the sort of impetus for my question to you is, if this was a major issue where you were seeing this over and over again, then I could certainly understand the justification for the change. But if you're not seeing a lot of issue with it, then I guess the question is, what's the need? It almost, to use a colloquialism that I like, it's a bit of a solution in search of a problem, because you're not describing that there's a massive problem here. You're saying this is really a sort of rarity that we're getting once or twice a year. And so why are we taking this out? Because it doesn't seem like this is the problem that needs to be solved. That's what I'm trying to understand. So if I'm misunderstanding, correct me.
No, and I think it goes back to that really this policy hasn't been changed. It's just putting it in a different area. So before, every section of the county code, Article 14, had a please request permission from the director or to get a permit. And I think the problem it presented the department is the public started to expect that any single area where it said, we didn't want you doing this. All they had to do was make a phone call.
Right.
So it became hard to manage on the ground. So I don't really think the policy's changed. It's been adjusted so that's in one section of the director's discretion, as opposed to making the public think, hey, I'll just give the director a call and we'll work this out.
However, I think the other side of the coin would be this, right? I like the idea that you can call the director and work it out, because to me, as a user group, if a user group has effectively adopted a park, one of our facilities, and they are really involved in trying to maintain it, that feels to me like that's helping you all do your job, right? They're sort of helping to elevate the standard of all of the rec and parks facilities, because you all are stretched thin, you're doing a lot of different things. So if you have volunteers who are coming in and helping, that seems like that's maintaining the quality of the system at a no or very low cost to the park system. So I guess that's the concern that I have, is if we're discouraging that type of activity, which seems to be elevating the entire system, why would we want to do that? That's the challenge I have. That's kind of the flip side of it.
Okay.
So, thank you.
Ms. Fiedler.
Thank you, Madam Chair. I want to touch on the updated definitions for e-bikes, scooters, etc. The definitions are now aligned with what the state has under their definitions. But the policy for what types of e-bikes are permitted on trails, that does not exist in code, correct? That's department policy.
That is correct.
Is there a reason why we are not codifying that? Because this is, I'll be honest with you, this is one of the biggest issues in my district. I've experienced it myself walking on the trails, where you feel like there's nobody around you, and then all of a sudden somebody goes flying by you, and you can feel how fast they're going. So is there a reason we haven't codified that, or?
A lot of it's just been getting up to speed with the various changes in state law, and then looking at what the county could do as far as rules and regulations which did not supersede or go against state law. That said, currently, about 3 weeks ago, we just put a brand new package together. We worked with Bike AAA and some of the other organizations, and do have new proposed rules that take a look at the different classes of e-bikes. So if you're not familiar with that, there's a class 1, there's a class 2, there's a class 3. It has to do with whether they're pedal assisted, the top speed they have, and we are looking to put some policies and procedures that would limit some of the problems that you and I have gotten phone calls on.
Yeah, I appreciate that. And I believe the speed limit is 15
It is.
on trails. So class 3, for instance, goes up to 28 miles per hour, but is allowed on trails, correct?
It is at this time. Part of the proposal would not have that.
Okay.
So we did also comparisons with what other counties are doing. One of the models we looked at was Montgomery County, who has started limiting it by class. Cautionary side of that is obviously looking at a bike as it flies past at 30 miles an hour is hard to decide what class it is, but those are regulations we're looking at adding at this point that would address the higher speed classifications.
Okay, and I think I appreciate that, and I appreciate the preview as well. I think for the public to better understand the rules, there should be some type of effort or even signage along the trails. This is something that I've talked to Bike AAA about. Even if it's a QR code or, every so many, 20 miles or 30 miles on a trail. I know that's long, but you can go really fast on a far distance on a bike. That just says these are the types of e-bikes allowed on trails. Because I think that it's just a matter of knowledge. I also don't know that those buying e-bikes or any type of e-transportation for minors fully understand the rules and regulations. Because once someone has an e-bike that can go 25, 28 miles an hour, it's hard to put the toothpaste back in the tube at that point. So it's really an education effort that I think needs to be undertaken. And I will say, even if we have all of these rules, people are going to unfortunately not adhere to them. And what I've tried to express to my constituents, it is incredibly difficult to enforce a speed limit on a trail with the limited number of park rangers, and we don't have officers on bikes like other jurisdictions do. So there's challenges in enforcing those speed limits as well.
Mr. Volkey.
Thank you. On page 6 at the very bottom, you have additional regulations relating to fire hazards. I wish the fire marshal was still here, because my question is vaping likely to cause a fire? I understand smoking, I get grilling, I get open fires, but I'm just concerned about the vaping. I'm curious about that. I don't vape personally, but I'm just wondering, does that create a fire hazard?
I know that was put in there. The concerns, more going back to the first bill you all were talking about, was the batteries themselves, as opposed to the active vaping. It's just, another device, a potential for it. We did not do any studies on that specifically, but looked at what other jurisdictions were putting in their code.
Okay, and I'm being a little flippant when I say this, but not entirely, but wouldn't cell phones pose the same concern with a lithium-ion battery as a battery in a vaping device?
So I know I had looked at that question myself. While the batteries are similar, I do know when the devices are activated, there is a metal coil that actually heats up. So that is one of the distinguishing differences between those two.
Interesting. Okay.
I couldn't speak to the likelihood of that causing a fire, but
okay.
Yeah.
All right. I just imagine if people who vape saw this, they might feel strongly that this was not a fire hazard. Who knows? All right, my next question goes to the next page, page 7, where you've defined litter and dumping. And in subsection 3, you say that people are not allowed on park property to display items that contain helium, mylar. So you can't have balloons on park property anymore. Is that right? Like if you're doing a birthday party and you rent a pavilion, I'm assuming that I can't bring my helium tank and fill up my kids' balloons and have those there on park property because that'd be considered litter?
yeah. So that is actually at our regional parks. I've been with the county now. This will be my 18th year. That has been the policy in our special event applications for each regional park. So it's codification of what has already been in practice. But you are correct in the interpretation of that. We have told groups for the 18 years I've been here that balloons, mylar, helium, and rubber latex-based balloons have not been allowed.
Is that being policed?
It is. It's policed. I'd go with a strong word. Obviously, rangers, first and foremost, education is what we go with. Our use of citations is extremely limited. We only issue somewhere between 5 and 10 per year, so those are 4 very serious situations. But our park rangers, when we do have a rental at a pavilion, stop by and check, and if there's a large 20 or 30 balloons, we do talk to the person about that.
And what is the policy reason behind saying you can't have helium balloons?
Basically, it comes down to for us, one, littering itself, as if they get loose, they're heading somewhere else in the park, to another jurisdiction, to another area we don't have control. But one of the bigger concerns we looked at it was from a wildlife entanglement perspective. That is why in many of the national parks, state parks, they're likewise banned.
Okay.
So the proposed bill only prohibits firearms. What about other dangerous or deadly weapons, such as paintball guns or knives or crossbows or things like that?
Not something that had been in the code historically, not something any of our superintendents. So a lot of this document, when we started working on that, I've made the attempt twice now in 16 years to try to update Article 14. It was put out to our regional park superintendents. Obviously, they have the most experience with the problems they deal with. And then it was also put out to our entire full-time ranger staff to discuss, and it was just not an issue that had come up. Some of the things that we would classify as concerning, weapons, knives, we have a lot of fishing spots, you know, having fillet knives and other tools. It kind of got into an area we didn't feel comfortable enforcing.
Okay, any other questions, discussion? Everybody still looking? Going once? Mr. Wilkie.
I have another question, thanks. It's really under the profit-making piece, and it's not expressly spelled out. It's on page 8, 14.2.112. Prohibitions, a person may not, subsection 3, utilize the department buildings, playgrounds, boating facilities, or other infrastructure to provide private instruction lessons or other business for which a fee is charged. So the issue that's come up for me is you have people taking photographs, right? And specifically, we had this at Downs Park the last couple years, and it's been a problem, where kids have been coming for prom, and they go down there and they want to take prom pictures. And I appreciate that the department has worked with the families the last couple years, but this has been a Northeast End of Chesapeake High School issue, where they've come to use the parks, and they're taking pictures, and they've been told, you can't take pictures in the park because you have to have a permit to do that, which has then just sent my community into overdrive. And I appreciate that the Rec and Park staff and the Rangers have found ways to make accommodations, but my concern is, by putting this in here, is that now going to become a constant issue that I have every year, where people are being turned away because they're being told that they can't do this because it's some kind of a profit-making activity?
It is not. In fact, we just 2 weeks ago met with the Recreation Advisory Board and have finished up our photo policy.
Okay.
Your specific situation, looking at the high schools, prom, special events that are very large scale, are going to be exempt from that policy.
Good, okay.
And we're going to be looking at those more as a special event, reaching out to the PTA, the school, the administration itself, and the police department to try to coordinate those better.
Great.
The only effect, the photo policy will be commercial photographers, not again at those events, but just coming in to use the park.
And what will be the fee for a commercial photographer? Like, if my wife wants to get pictures and we go to Downs Park and meet a photographer, how much am I going to have to pay on top of the photographer's fee to use the park facility?
I'd have to get back to you on,
Okay.
What's that?
Erica Matthews, $50.
50, okay, all right. And then the next piece of this says fundraise at a rec and park area. So again, getting back to the question that I had about the user group doing fundraisers, I'm assuming that this can be waived by the director as well. Is that right? The prohibition on fundraising?
Correct.
Okay, so if you had a user group that used a particular park who said, we want to hold a fundraiser, the director could grant the authority in their sole discretion on whether or not to do that. All right, I'm already like typing the email of the amendments I want for this bill, because that's what I do when I'm here. And so my question to you is going to be, do you have any problem with the appeal of the director's decision to the Board of Appeals? Do you have any issue with that? If the director were to make a decision and then someone disagreed with it, to be able to take it to the board?
I think the question would be the timeliness of
Sure.
that.
Yeah.
In my experience, again, this goal is not to impede everybody's use of these public facilities.
Yep.
It's better to trying to align with current recreational opportunities, align with procedures that we currently have in place, and then to make sure that we are in accordance with state and other county regulations. I think going to the Board of Appeals is a timely process, and the event that's typically being asked for wants to happen in the next 30 to 60 days, so I'm not sure of the timeliness.
Yeah, and I would agree with you that if poor planning by the event organizer puts them in a predicament where they ask for permission, the director says no, and they try to file their appeal and there's not enough runway, that's the event organizer's problem. They should have started earlier. But to the extent that they do start early enough and they do go in the process and the director does say, for whatever reason, I don't think this is the appropriate path to move forward, I'd like to give them an avenue to be able to appeal that. And if they've started early enough, I think the Board of Appeals gives them that. The board currently has to balance state, local, all these different laws when it comes to development applications and other decisions that they're making. It doesn't seem like this would be that far outside of their purview to be able to sort of assess those decisions and be a neutral arbiter beyond the director. So that's the way that I'm looking at it.
Well, to take a page out of your book, I
Go
think
ahead.
you're looking for a problem that doesn't exist.
Okay.
I mean, there have not been that many permits that come across the desk that are not approved.
Yeah.
Typically, when a permit's not issued, it's the applicant has not provided us all the information that we've requested.
Yeah.
we've offered an alternative location that can better handle that event, and then they choose to not have it there, or they don't understand all of the pieces and the rules that we have, and their activity just doesn't align with the rules that we have in place. But very rarely do we tell people it's a flat no.
And I'm going to say thank you, because I appreciate that. I always appreciate when the department finds a way to get to yes, as opposed to just saying no, even if the yes is not what people originally asked for. So I thank you for that. My only concern is you're reasonable, you're a good administration. I don't know what the next administration is going to be, and I don't know whether the director is going to be as accommodating. And so that's the concern I have, is that by codifying this amount of power in one individual, you're really giving that person exclusive authority over that area.
But this person has always had that authority. It was just sprinkled about in every single line item, and all this did was just push it to the front.
I got it. And when we push it to the front, let's make sure we're pushing it to the front with an avenue that potentially gives an outlet valve. So I hear you, and I think I like when you take a page from my book. I appreciate that. So, all right. You're copied on the email, so you will see all the amendments. As will Mr. Hunt. Yeah.
All right. Any further questions on this bill? Thank you very much. All right, bill number 726, supplementary appropriations. Mr. Hunt.
Thank you, Madam Chair. Ethan Hunt for the administration. I also have TJ Mayotte, our Deputy Chief Administrative Officer, Kelly Kenny, our Supervising County Attorney, Tony Gedden, our Health Officer, and Chris Trumbauer, our Budget Officer. So this legislation introduced at our request transfers funds and makes supplemental appropriations to the current expense budget for the year ending June 30th. Appropriates $868,400 from the unappropriated general fund balance in reserve for federal impact funds, and $178,600 from unappropriated balance in the Pimlico and Laurel Racecourse Grant Fund, for a total of $1,047,000. And I can turn it over to Dr. Gedden and Mr. Trumbauer and TJ for any questions or to offer additional comments or details.
Mr. Volke.
I'm still on. Look at that.
Look at that.
I forgot my light was even on.
Oh, but we all knew. Just let it keep going.
Yep. All right. Can you just walk through, since this is the first time we're seeing this, what's going on in this bill? I mean, I see the chart that you have, but I'm just trying to digest the numbers. Mr. Trumbauer, this is always the place where you shine.
Chris Trumbauer, Budget Officer, not looking to shine, just to answer your question, Councilman Volke. If you look at the fiscal note on page 2, it shows you Exhibit 1, which shows all the money moving around, but essentially this bill is doing 3 things. The first is that it is moving the money from the $500,000 was the commitment the administration made to the food bank last fall when the SNAP benefits were in jeopardy from the federal administration. So you might remember that we did that money out of the CAO budget at that time, so we're now backfilling that with the $500,000 of the reserve that was left in the 26 budget to deal with federal impact. So that's the first maneuver. The second thing, and Dr. Gedden is better equipped to discuss this than me, is we're doing an additional appropriation out of that fund in order to meet some new requirements that the federal government is putting on our Medicaid eligibility process, okay? Then the third thing, which Mr. Mayotte is best equipped to speak about, is recognizing a state bill from the previous session that somehow slipped past the radar in our budget, where we did not accommodate funding from the Laurel Racetrack Fund. So that's a so all 3 of these are really reconciliation maneuvers, but those are the 3 buckets that this bill addresses, and the exact amounts are in the bill, but also referenced in the fiscal note. If you want to know more about the how and the why, the people to my left and right are better equipped than me to discuss that.
Well, I'm going to ask you about the $500,000 for a second, just because that's the one that seems to be just my question. So refresh me on that. In the budget, we appropriated how much to the food bank? Was it $1 million that we gave to the food bank?
In the current FY26 budget,
yeah.
I think all told it was $1.5 million.
$1.5 million, okay.
Yeah.
And then with the $1.5 million, so that appropriation was in there, but then there was an additional commitment of another $500,000 that the county executive made
That was back in the fall.
after we'd passed the budget.
After the budget. It
Yeah,
was
okay.
when the SNAP benefits were stopped because of
Got it. And
federal
so-
things beyond our control.
Yep, understood. And so that $500,000 was a commitment the county executive made, and so now this is codifying or sort of fulfilling that commitment by making the transfer from the CAO contingency fund with the $500,000.
So at that time, because the need was urgent
Okay.
and the legislative process deliberately takes some
Time,
amount of time,
yeah.
we used existing appropriations in the CAO budget. What this bill does now is it backfills those existing appropriations we used for the 500,000 with the money that was held in reserve for the federal impacts.
Okay.
So that's why I called it a reconciliation.
So are all
So this
in-
makes the CAO office whole for what it kind of forward funded.
Okay. So the total appropriation, if you will, from all sources for the FY26 budget, when we sort of reconcile at the end of FY26, is going to be $2 million to the food bank? Or is it going to be 1.5?
No, I believe if you count this towards that
Yes.
math, then I believe you're correct, but
Okay.
I will double check that before
Okay.
the public hearing to make
Yeah,
sure.
that's just what I want to understand
Yeah.
is like, are we going to the 1.5 that we appropriated, or are we adding an additional?
No, it's
$500,000?
definitely an addition.
Got it.
And the reason I'm hedging is because I know in the budget, there's a direct appropriation that's given to the food bank, and there's also some money that travels through, partnership or other departments that makes its way to the food bank too. So I think that aggregate amount is 1.5, and this 500,000 is on top of that, so that arithmetic would be 2 million. I just want to double check that I'm correct.
Okay, fair enough. And Dr. Gettin, can you speak to what the federal mandate is on the county that is now increasing our cost?
Sure.
Thank you.
There's several changes, and we spoke about this in the Board of Health presentation in October, and we'll be bringing it back this spring to
Okay.
make sure everyone is aware. But with Medicaid this year, towards the end of the year and the very beginning of 2026, we will see eligibility changes for current enrollees. And there are two groups with the largest impact, but there is one impact that goes across all enrollees. So I'll start with that one. And roughly there are between 102 and 103,000 people in the county that are enrolled in Medicaid. That first change is retroactive active coverage. So right now, if for whatever reason your coverage lapses, you have about 3 months to get coverage back, and that you can back bill. Your providers can back bill Medicaid. You're not incurring those bills. For expansion adults or people who received Medicaid as a result of the Affordable Care Act, those individuals are going to a 30-day retroactive window, which means for our office, who is enrolling people and making sure that they stay enrolled, we have to get you back in much faster than we had to before. For everyone else, they're going to 60 days, right? Well, whereas everyone's had 90 days previously. So that's the first change that covers everyone across Medicaid groups.
Can I ask you a question on that?
Sure.
I don't mean to interrupt, I'm sorry, but while we're on that train. So what is the increased cost to the county?
Sure. So there are Medicaid eligibility specialists
Okay.
that work for the Department of Health. And those individuals are the people who sit down with you and fill out your application, make sure that everything looks correct, that you're staying enrolled, and if something's missing, we're getting back to you. So it's the cost of those staff members that work in each local health department across the state that we have to make sure we have enough people to do that work, and the workload will increase.
So this will hire additional people to make sure that you're covering what you see as an increased workload in the short term, because these folks are going to help with the tighter eligibility requirements
Yeah,
or
and I would
timeline.
say this one isn't necessarily in the short term, right?
Okay.
Because that is an ongoing thing that people
Gotcha.
will have to do to get to make sure that their coverage stays up to date. And for whatever reason it lapses, we'll have to continually get you in on that time frame.
So then this would be a recurring cost that you anticipate you will work into your budget request coming up in a couple months.
As long as Medicaid eligibility stays this way, yes.
Okay. Do we anticipate from the federal level that that will change at any point in the near future?
I would not be able to predict that.
Fair enough. Okay. All right. I'm sorry for interrupting you on that.
No.
There was more.
Yeah, so that's one. One of the other changes that's coming in October is a number of individuals who have various immigration statuses will lose eligibility. So for those individuals, a part of what we will be doing is making sure that folks know that that's happening, and what other resources are available to people who are no longer eligible for Medicaid insurance. And then the largest change goes into place at the beginning of 2027, I apologize. And that is for expansion adults. They now have to meet a work requirement as well as coming in to re-enroll twice a year. Right now, we enroll those individuals once a year. It's roughly 25,000 people in that category. And so instead of seeing those people 25,000 times a year, we're going to have to see you 50,000 times because we need to see people twice. So the same thing, we need to increase the number of staff because we're going to have to increase the number of visits that people have to enroll and keep their Medicaid enrollment.
Okay, and so then switching to Mr. Trumbauer for a minute. So we're doing the thing that we don't like to do, but I'm assuming you have a plan because from what I can tell, appearing to fund an ongoing expense, because it doesn't sound like this, at least from the health department side, is going to be a one-time funding thing, using one-time money, fund balance. Am I understanding that correctly?
Yeah, that's all we can use in the current budget. So as Dr. Gedden explained, there's an FY26 need. We're using the money in
Fund
reserve
balance, yeah.
to do that. The department's request will be presumably for recurring funding in FY27, which
Okay.
we will tackle and this council will tackle in a few
couple
months.
Yeah, okay. All right. I don't have any questions about the racetrack, so I'm sorry to not have anything exciting for you.
I can feel his disappointment emanating from him, for the record.
All right. Are there any other questions? All right. Thank y'all very much. All right. Next is Resolution 226, urging the county executive to provide transparency and allow for more public input on the budget. Mr. Volke.
Hi again. All right, Mr. Trumbauer probably hates this resolution, but I did tell people it was coming, to be fair. All right, so my concern is this. This is a very tight fiscal year, both at the state and probably at the county. I think it's going to be a tighter year, having gone to the budget town hall with the county executive. He certainly was sounding that note in some of his remarks in those budget town halls. So to the extent that there is an ability for us to understand what the budget is going to look like, at least from a preliminary standpoint, I think that giving that information sooner rather than later would be beneficial. Now, certainly the county exec is in compliance with the county charter and code, which always requires that at least 60 days, says not later than 60 days prior to the end of the fiscal year, the county exec must submit the budget. So that is why May 1st is always the date on which the county executive does provide the budget. However, there are, as we all know, a lot of decisions that are made behind the scenes, and the budget office works year-round on these projections, both from a revenue side and then from an expense side, to be able to craft a budget each year. So with that being said, we are one of the latest counties in the state of Maryland in terms of when we present our budget and start. And so I say that because it would, I believe, be helpful for all of us, but especially for some of the groups that are most affected by the county budget, to have a sense of what a preliminary budget will look like, at least when it comes to revenues and expenditures and the ability of the county executive to fund certain things. Because as anybody who is a keen observer of the county council knows, once the county executive presents the budget on May 1st, all of the deliberations for the county executive are done in private. And then the county executive sits at the podium, or stands at the podium, over here, and presents that to the whole county and tells everyone, here's what's going on, and tells us for the first time, here's what's going on. And then the county exec says, good luck, county council. I wish you the best. I hope that during your public deliberations, you're able to find ways to make my budget better. Have fun. And so everything we do is entirely in the public, and everything the county executive does is entirely private. And I feel that there is a disparity there that needs to be corrected, at least to a certain degree, where the county executive has to give a preliminary idea of what the budget's going to look like, and that way groups can see that and start talking to the county executive prior to the actual presentation moment, so that these groups are aware of what this is going to look like for them, because again, as we all know, huge percentage of our costs in the county are personnel costs, and so the decisions that we're making, as everyone up here is keenly aware, are affecting people's dollars and affecting what their lifestyle looks like, because these are people who are working for the county, and that's the biggest thing that we fund. So with that said, I would ask for my colleagues' support on this. I think this is a reasonable measure to request that the county executive give some vision, at least to the public, not just to those behind the scenes, on what the budget is looking like a little bit earlier than normal. I recognize that there are concerns with the state budget. I recognize that we may hear from the administration and others that the concern is that the state budget has not been finalized by April the 1st, and so there are, concerns that we won't be able to give a perfect picture of what the budget looks like. I'm cognizant of that. I'm not asking you for a perfect picture. I'm asking you for a preliminary budget idea, and other counties do this as well. So I think that we can do it. I think that Anne Arundel County possesses that ability. We have a great budget office, so I know they can. Thanks.
Mr. Trumbauer, I know you're ready.
Thank you, Madam Chair. Is there a specific question you want me to answer, or would you like my general thoughts on Resolution 226?
He's asking you.
Oh, me?
Yeah.
I'm not the chair. He has the chair.
Okay, well, I would like your general thoughts, Mr.
Well, thank you. I guess I'm curious for the sponsor if he remembers the town hall where he sat next to me in the county executive previous month in January. He remembers it. Okay, good. He was there. So as part of that town hall on slide 15, he may remember, and he was on the other side of the screen, so I couldn't tell if he was paying attention or not. But so that's true on that setup at the high school. So there was a slide 15, and I think largely we delivered in that slide what my interpretation that the sponsor is asking for, which is a chart that had 3 buckets of the expense budget broken out. There's the kind of what we call built-in increases, which at that time we estimated at about $40 million. Then we had the county pay packages, which it's impossible for us to estimate because negotiations are ongoing now. And then we had the county adjustments and supplementals, which is what, in previous times you might call discretionary funding, although I don't like that word. But those are the things where we can put into new efforts and new projects. There's not a lot that's going to change between January, when we did this very public and very transparent slide, and we did this 8 times for 8 town halls, and April 1st. So I'm not entirely sure what the sponsor is trying to get out of this. The second point that I'd like to make is that the budget office is a pretty small and tight group, and I have 8 budget analysts. And starting a couple weeks ago, all the way until the end of April, they're going to be working extreme hours. And what I mean by that is 4 o'clock is not the end of the day for them. They're going to be working evenings. They're going to be working weekends. And they're going to be working on the real budget. And so anything that takes them away for another work effort is going to jeopardize the time and that we have for our charter mandated requirement to get the actual proposed budget to you all by May 1st. And that is what troubles me most about this. Now, I can type up a memo for you on April 1st, and I can give you an update of this chart, and I'm happy to do that. And you have my phone number, and you can call me anytime, as can the other 6 council members. And we have a good relationship, and we share things, and we give information to the auditor's office before May 1st so that they can get a head start on their analysis. We've done that every year that I've been budget officer, and I will keep that commitment. So I guess my question to the sponsor is, you don't need to pass a non-binding resolution telling the administration to put out a preliminary budget. I can work with you to give you whatever information that we have and is it able to be shared. So that's my comment. I would ask the council at the when it hears and votes on this to reject this. But in doing so, I will also reemphasize my commitment, and I think I have a track record to demonstrate that I will work with the council as a whole and individual council members leading up to the budget and throughout the budget, even after May 1st, to give you whatever information that you need. I just don't see the point of Resolution 226. That concludes my comments.
I appreciate your comments, and I just want to say a couple things. You have always been transparent with the members of this council, and as a former member yourself in the minority on this council, you've always been extremely respectful to the minority members on this council in providing as much information as you can. So I hope that you don't take this as a shot across your bow, because that is not the intent. All right. With that said,
I try not to take work personally in general.
I appreciate that. I do.
It's been a very important thing for my life.
I can respect that. With that said, so the point that you hit that I think is an important point is you are extremely transparent with all of us, and I appreciate that. That's not the measure of this resolution. The measure of this resolution is the transparency with the public at large. It's the transparency with any departments or any union groups or anyone who is really paying attention to this budget, even people who are citizens who are looking and saying, what is this going to do to my bottom line? That's the purpose with this. It is not because you're not transparent with us, because you are. It is that the administration, I believe, by April 1st has a pretty solid idea of, are we going to add more police? Are we going to be able to add more firefighters? What's the pay package going to look like for the council? What has been negotiated in terms of the pay package between the represented different groups in the county? And what are they going to do in terms of the pay package for the represented and non-represented groups? I believe, you can correct me if I'm wrong, that most of those negotiations, as you put it, that are happening between January and April, by April 1st, you have a pretty solid idea of what you're going to be able to do on those things. Those negotiations are largely concluding. So that's the difference. That's the piece of the puzzle that, as you put it, yes, we know the pay packages, you have sort of a placeholder, but you have a solid idea of what the pay packages are going to cost by April 1. And then that gives you an even better idea of how much excess money you have that is available. I call it excess, but I mean the money that's left after you've done all the things you have to do to be able to say, where are we going to put this and what incremental change are we going to make in the county? And so that's what I'm looking for the county executive to provide, is more detail on that, because I think that you have it, and I think that the public and these other groups that are very interested in what the budget looks like for them should be able to see it. That's the purpose of the resolution. And I understand we may disagree. What I'm suggesting to you is I don't want your team to go and put together some fake budget that you're going to put out. If you're working on the real budget, I know you are, and you're working as hard as you've noted that you are, by April 1st, you have a pretty good idea of what the real budget looks like, and I'm asking you to give us a snapshot of that. That's all.
Madam Chair, may I?
Yes, sir.
Thank you. I appreciate that, Councilman Volke. I'm having a hard time reconciling that with line 31 of your resolution that says it basically urges the county executive to release a preliminary FY27 budget, ... I thought I just heard you say you didn't want us to put a lot of work into doing a different thing. You just want more transparency. So again, I would urge the council to reject this resolution, but at the same time, I take your point and I'll double down my commitment to work with you. If there are additional things that we can release, leading up to May 1st, we're happy to do that. But the reality and the bottom line is that on April 1st, I might be able to update some of this. Like we projected in January, and we told everyone at the budget town halls, which is public. We said that our initial revenue estimates are $120 million of incremental recurring, okay? On April 1st, maybe that's 123. Maybe it's 117. It's going to incrementally change. Will we know the pay packages by April 1st? Hopefully, some of them. Some of them tend to drag on lately, especially, well, I'll let you guess which ones, but they've tended to go right up to the wire. And you never know, some may go to arbitration or impasse. So they may ultimately end in your court anyway. So I just don't know. This has been, and I was first elected to the county council in 2010. We got bupkis leading up to May 1st. I got to learn what was in the budget from the county executive at that time standing at that podium. Each one of you gets a meeting with myself and the county executive a week prior or in that week leading up to tell you what's in the budget so that you can prepare and you can know how you're going to react. I never got that. There were never, before Councilman Pruski's bill or charter amendment that required the town halls that we now do 8 of, until he passed that charter amendment, which requires 2, there was never any public outreach on the budget until that point. We're not doing 2, we're doing 8. Now, we can debate whether that's a good idea or not, but we're doing 8. The next administration will get to choose how it interprets that. But this is, just by comparison, in the last 15 years, it's exponentially more transparent and open to the public. The fact that we are showing this table in January, I think essentially meets what you're trying to do. And I can incrementally update it. I can share what we can at that time. But the reality is we're not going to make final decisions by April 1st. So anything that I was to release or that the administration was to release, it's going to change again. It's likely the state budget won't be concluded by then. Who knows what we'll be reacting to from the federal government. I don't know which union negotiations will have tentative deals and which won't. So you're just getting one more iterative step that could change. And substantively, I don't believe it'll be that different from what we publicly showed in January. So I appreciate your intent. I'll double down my commitment to work with you all and release what we can publicly that will be helpful and productive. I just don't think this is a good idea.
Ms. Fiedler.
Thank you, Madam Chair. I did not draft this resolution, but I did hop on because of feedback that I've gotten from constituents, not necessarily employee groups, but constituents who hear the discussion that we have at the beginning of the town hall, and I've referenced, and then the county executive sometimes gives us a preview. I've had constituents come up to me and say, well, why can't we get that preview? Why can't we know? I understand that it is complicated. And I also know that there has been discussion off and on throughout my terms in the seat to go back and amend the charter with relation to our budget because we are a little bit of an outlier in how we time things. I don't know that, well, one, we couldn't do a charter amendment before this budget, but two, I see this as an opportunity to kind of test the waters for a potential charter amendment down the road. So that's why I hopped on. But my question is, since you pointed out the language in line 31, I understand you're opposed to the way it's currently written, but hearing the discussion between you and Mr. Volke, I don't think that you're too far off where there's a potential to do something and there's a desire for the public to see something. Is there an opportunity to amend the resolution to provide a last and final update to the citizens? Because I know you did 8 and I only did 1, and residents of District 5 mostly only came to 1. So I know it feels like the administration has, and they have, to your credit, done a lot of town halls, but each individual district only feels like they get 1. Do you see what I'm saying?
I have some great news for you, Councilmember Fiedler. They're all available on the Your Budget website, so you can watch all 8 of them if you'd like to, and all of your constituents can too.
They're still going to be eager for, okay,
But okay, so let me just back up. Okay. What is it? We had a town hall in each of your districts, and we let anybody who wanted to come and say, what would you like or don't like? Give us your comments on the budget, okay? And we did that after we gave them a preliminary update on what we expect. What is your intention on April 1st? To say, you've had 3 more months to think about it, now what do you want? Like, I don't understand what you're trying to get out of it. Like, we've had our public engagement, we've asked the community for their priorities, we heard them. Even if no one came to the town hall, we have a email set up that's been well advertised where people can submit their comments, and I assured the crowd, and I'll assure you all, every single comment is read and categorized, and the county executive gets briefed on it. So I'm not sure when you say we only had 1 town hall, like, what is it that the community is missing out on?
I think what the community is missing out on is the meetings that you have with individual council members. And I agree with Mr. Volke. This administration, specifically you, Mr. Trumbauer, have been very transparent with us. But what the level of frustration that I'm hearing is, okay, we go to these town halls, we give our priorities, the council members who represent us know off the record what's coming, but we, the public, don't know. And by the time the budget bill is introduced, the council can only cut. There's no like last ditch effort for the public to give feedback on the preliminary budget. So I think that's, again, I did not draft it. That's how I interpreted it. Basically to have a public presentation of what privately, one-on-one, some council members get. I don't know if everybody has it.
Well, I just think council member that we may have different philosophies about how all that works. I sat up there for 8 years. I was very engaged in the budget. You've all been very engaged in the budget. 45 days in one hand seems like a forever, but it also seems to go by like that. I actually personally believe that by having Anne Arundel County introduce its budget late on May 1st, it's an advantage because we know everything that's happening on the state, because we get more economic data, so we can be tighter. Other counties are having to do constant revisions once they introduce it, and it's a mess and it's more work. So I appreciate some people may feel like 45 days is too long. Some people may feel like it's not enough. That's what we have, and whether or not that date or that duration changes is separate from this resolution. But your question to me was, how would I feel if you amended the resolution? I mean, you guys can do whatever you want. There's a non-binding resolution. The administration could take this and say, great, thanks, and never do anything again, right? But that's not how we roll. That's not what we want to do. What I'm telling you, my preference as budget officer, and Mr. Hunt can speak to the official admin position, I'd prefer that you not pass this to set up, some, expectation that could be interpreted different ways. But instead, we just continue to work together as we always have. If there's additional things you want, you know how to reach me. You can ask the county exec. We can put out more information as it becomes available. But I just don't particularly relish the idea of having to come up with another specific work product that was requested by the county council via resolution at the time when we're working 100% to get to May 1st. So that's my point. I don't think we're very far off on what you guys want and what I'm offering. I almost wish we didn't have to do it legislatively. We could just come up with something to help you feel like you're better serving or communicating with your constituents. But, you guys have the authority. You can change this, you can pass it, you can defeat it, and we'll work with you the best we can at that point. But I'm just telling you, my preference is not to pass this resolution.
Mr. Smith.
Thank you, Madam Chair. So I think I'm trying to understand and interpret the sponsors' sort of perspective. And so you give me a few moments here. And I agree with Mr. Trumbauer on the timeline. Obviously, May 1st and April 1st and May 1st is not going to be a significant sort of influx of new information. I think, and I'm interpreting what the sponsor is trying to come from when the administration is doing the public hearings. It is receiving information from the public. There's no deliberation. There is no debate. There's no back and forth between those. Let's say on the District 1 meeting that we had, there may have been. And before I want you to know, I actually agree with your perception of this. So, but I'm playing devil's advocate here. But there's no back and forth at those public hearings about which items will get funded and which items will not. When the public finds out about what got funded out of those requirements, it really is when the May 1st budget is submitted. And at that point, the council then gets the budget. And if we want to move money from different components, it is a very public sort of activity where, if I have an amendment, it's going to be communicated between me and everyone on this council, as well as those who are impacted by it, where they say, well, why are you targeting our resource? And the reality is we're talking about less than 1% of the budget that we actually, 99% of the budget is what we did last year. And we're going to continue to do those things last year in the upcoming year. And so, what we negotiate on or what we debate on is really the fringes of the budget, that probably 1%. And so when that comes to us, we're having this public discussion on the council as well as with the public. And then they assume that we're taking something from them when what you give us is just a proposal. It's not the budget, it's a proposal. And so, we get beat up on if we're moving money to place in education or whatever the case is. I say that to say it's a very, very sort of public sort of activity. Whereas I think where the sponsor is coming from, when you all have those agency sort of conversations, the public isn't involved. So when you have 5 projects and you choose to do one, the public isn't looking at you to say, well, why didn't you do project 1 instead of project 5? So I think the sponsors, and that he can certainly correct me if I'm wrong here, is to, put a little bit more of that into the public dialogue prior to it coming to us, and us being the ones who bring the bad news and being blamed for things that are being cut. I say all that to say I think I understand where he's coming from. However, when you look at the mechanics of the state budget and our budget and what's practical and what's not, the projections that you do put out as far as the revenue that streams that we're going to get in is a sort of abstract number. People don't know exactly what that particular resource is going to be applied to, even though we have those public input sessions. It's only when it comes to us that now we know where that money is going to be applied to and what the effects of it is. And so I see both sides of this, to be honest with you. I see why the sponsor would bring this forward. But to your credit, I'm not sure there's a practical pathway to be able to adjudicate that over the first couple of weeks of April to be able to accommodate a more robust sort of session that would happen within the county council chambers when we do amendments on the budget. And so I hear you, but I did want to recognize and am asking, is that?
Yes.
Okay, I just wanted to make sure I was trying to interpret what you were communicating.
Well said.
Thank you.
Ms. Pickard. I'm sorry, I didn't see the order of everybody. I was just working down the line. Sorry.
Thank you. I wanted to reiterate what our budget officer noted about there's a couple other large counties that do their budget work, their annual budget work before the end of the legislative session and end up going back and having to revise. It was sort of one of my points about what I don't understand this resolution. But mostly what I don't understand about this resolution is if this council or the sponsors really wanted to rework the way Anne Arundel County does its budget, this is a little late. This should have been a conversation that was teed up a long time ago in order to make it at all even workable for our public servants in the budget office. It was just a little late to the party. They're already well down a path that their deadline is May 1st, and you're asking in the middle of February to retool the way we do the budget. I don't understand. I agree with Mr. Trumber. I don't understand what you want to see. The PAB will be deliberating the next 2 Fridays on all of the capital budget. My staff sits in on that, those very long days. I believe that those are public conversations. If there's a specific project that a constituent wants to understand better that's in their district or near their house or what have you, there's all kinds of information out there if our constituents want it. I've not had a single person in my 85,000 member district concerned about this, the way we do the budget. But then I haven't knocked on all their doors and asked them personally and delivered a budget message to each of my constituents either. So I just don't know what you would want presented on April 1st, and I certainly do not want to derail the hardworking public servants away from the task at hand for a May 1st deadline.
Ms. Rodvian.
Thank you. I think Councilmember Pickard said everything that most everything that I wanted to, say, but I'm in the same situation. I don't think I've had anyone come to me and ask about, what do you know? Is this going to be funded? Is that going to be funded? And if they did, I'm 100% confident that I could go, and say, this is what we're doing. This is where we're at. We'd like to try and get there. We can't get there, whatever, and have that information. So to me, this just throws a wrench in the works of them trying to get their process done, especially April 1st, before the state has usually finished their budget. So it's almost like giving out what could actually create more problems down the road because we're giving something that's not based on the full picture that we won't have until session concludes, until the General Assembly session concludes, and then set up, unrealistic expectations because things change. So I don't like that we're spending time on this. I would like the budget office to have time to work on the budget and not have to worry about an extra project thrown in the middle of it that's going to be under public scrutiny. And I want to remind my colleagues that you're correct, that in our process, we can only make cuts except with respect to the Board of Education, but we've every single year made supplemental amendments based on what our conversations and conversations that we've had after our budget hearings where we hear additional feedback. So to me, this just adds a whole, like, this is just repetitive of things that are already happening. And I don't want to put that on the budget office. I don't think it's necessary. I think we have a really good process and transparent process in place. And I would like to stick with it and not burden them with, something that may actually end up causing more problems because it gives an incorrect perception of what the county budget will be just 30 days later.
Mr. Volkey.
I was going to appreciate everybody's comments. This is the most hotly debated item on the agenda, as usual, when I put something in. So anyway, I appreciate that. Thanks for all the comments. Mr. Trumbauer, thank you for coming down. Mr. Smith, thank you for summarizing the position very eloquently. Much appreciated.
But I will say we were hotly debating the battery storage things too. So we're having a lot of debate today. Mr. Smith.
I was just going to lastly say, unlike some of the other larger jurisdictions who have subcommittees that actually spend a lot more time dissecting the budget as it comes in, we're not sort of constructed in a way that allows us to do that. And so our charter and the way we process, I mean, you bring it up. I would say also, if it's something that members on this council care about how we do our budgeting, maybe look at charter amendments and sort of changing that if you feel strongly that way. But we're sort of almost like a board where we do up or down the entire budget. It sucks. I mean, there's some pros and cons to it, but I do agree that it's April or May. I'm not sure what the value is going to be out of that process, but certainly understand why the sponsor would bring it forward. Thank you.
Ms. Pickard.
I seem to recall my charter member to allow for this body to create standing committees was defeated and was not sent to the voters. So that leaves us doing our work in the body of the whole and leaves us in maybe a less sophisticated way to legislate and be the final fiscal authority. When and if this council wants to move forward and be a more robust check and balance on the executive branch, that's the kind of work that's going to happen. It'll also probably mean, additional staff for the council, for district offices. It'll also probably mean moving more towards full-time council members. And that is something that this council has not agreed on. But if that's the kind of work you're wanting this council to be more engaged like that, there are mechanisms that we would need to put in place prior to that. Thank you.
Madam Chair.
Yes, ma'am.
And actually, I just want to note that our salary commission actually, I think, was very seriously considering moving towards a salary that recommended full-time. But my understanding is that the representatives of my colleague, Mr. Volkey, strongly worked against that. So adding more workload to a council that is already hamstrung because we are part-time, and you included work a full-time job, is completely inappropriate.
As always, I appreciate everything. I do.
So, he's headed out, but I'm just going to echo what Ms. Rodvian said, that we see how very volatile the state budget is at this point, and every day we're hearing of possible new things that could be passed down to us. And so I think there could be a lot of change between April 1st and sine die as to what comes through. And I think we could be giving people some really false hope if we stated certain budget priorities that had to be totally switched in those last 2 weeks. So I agree with that. But I echo what everyone said. Mr. Trumbauer, we are always very grateful for how transparent you are and the information you do share with us, and I feel certain that you will continue that no matter which way this resolution goes forward. So we will now move on to resolution number 326. This is a resolution regarding the redistricting from the House. This is Mr. Volkey's bill, and he has had to leave, but Ms. Fiedler, you are...
Madam Chair, I just would like to note that our council member that was unwilling to move towards a full-time counsel, has just left in time for us to discuss his very resolution. And that is exactly the kind of example that is extremely frustrating. So the rest of us that are here are now taking on the burden that our colleague has acknowledged he cannot handle because he has to go to his other job. So I will leave it at that.
Ms. Fiedler, would you like to speak on this resolution?
Well, I am not the lead sponsor of this resolution, and I have not spoken to my colleagues if we are going to be proceeding in light of recent events. But yes, the resolution is making a specific request of the General Assembly, and it is what it is.
Okay. Anybody? I personally don't see us needing to have that debate here today in the work session. So if we want to move on, move on. Okay. We will now discuss the draft of the Article 18 update legislation. This is a big one. So,
Is indeed. So while the team comes up to the table, just for the record, Ethan Hunt for the administration, Kelly Kenny, our supervising county attorney, who I believe might have to depart shortly for a meeting. I also have Jenny Dempsey, our planning and zoning officer, Lynn Miller, our assistant planning and zoning officer, Sterling Say, our planning administrator, and I don't believe Donnie is here. Donnie could not make it. Okay. So Article 18, we have discussed with all the council members. This is a comprehensive update to the planning and zoning code. It is a big one. I will leave it at that and turn it over to Ms. Dempsey.
Morning, everyone. Council President, members of the County Council. I'm Jenny Dempsey, Planning and Zoning Officer for the Department of Planning and Zoning. We are here today to brief you on Article 18. The Office of Planning and Zoning has been tracking needed changes to the code for many years. Upon my arrival in 2023, staff had nearly 200 line items in a spreadsheet, which has grown to over 300 items before you now. The last comprehensive update to Article 18 was in 2005, which was 21 years ago. Since my time in OPZ, I have heard from the development community, attorneys, developers, engineers, and organizations about the need for an update to Article 18. The proposed amendments cover a wide range. The final summary report provided to you, and which is on our website, breaks down the amendments in 9 categories, which are descriptive of the types of amendments included in this effort. After preparing a preliminary draft list of proposed amendments, the Office of Planning and Zoning created a website to seek comments from the public. The public comment period was open from August 11th, 2025 to September 19th, 2025. During that time, OPZ received comments from MBIA at about 40 comments, NIUP with 43 comments, GAN 37, and about 105 comments from the general public and county staff. OPZ issued a final summary report on its website in December of 2025, along with a final draft list of amendments that reflects any changes made based on the feedback received during the public comment period. To assist in the review, we have provided an index to highlight those topics that relate to multiple line items in the amendment matrix. I have Lynn Miller here with me, Assistant Planning and Zoning Officer, who's going to provide a brief overview of the topics listed in this index. And as we go through this, please let us know where you want more detail. I'm sure there's going to be a lot of questions, and we're happy to take those questions as we go along. And we also would just like to take some time at the end to discuss any items that are not in this index matrix that has been provided to you.
Ms. Miller.
Thank you. Excuse me, Lynn Miller, Planning and Zoning. So again, we're going to be working from the index that we shared with the County Council, which represents over 30 topics that have line items that multiple line items that appear in the matrix. So starting with accessory dwelling units, we have added a definition here that we've revised based on state code that was state law that was passed last year, which specifically addressed detached dwelling units, and our code is not exactly consistent with that state definition. So we're changing that. I will note that it doesn't have an impact on our detached ADUs. Our detached ADUs are limited to the lesser of 800 square feet in size or 50% of the principal structure, and that is more restrictive than the state law, so we will continue to have that in our county code. That's number 27. 238 is just changing this from permitted to conditional in the OTC use chart because the ADU use does need to have the conditions that go with it. And 268 are those conditional use requirements. Okay, moving on, accessory structure. We've added a definition here. This is really to distinguish an accessory structure from an accessory use because there are places in the code that have provisions that apply to accessory structures that would not really be applicable to an accessory use. So we needed to distinguish between the two. So number 77 is that definition. 97 is a provision that relates to this 3-foot distance requirement in the code that we're clarifying that a structure that's detached from the principal structure is accessory regardless of whether it's 3 feet, 5 feet, or 10 feet from the principal structure. 98 is some provisions that deal with accessory structures on a different lot. And again, we're clarifying this just to make sure that it applies to an accessory structure, not accessory use. This is the provision that allows that and if an owner has 2 adjoining lots and they own both, they can have an accessory structure on the unimproved lot as long as it's used solely for their own purposes. 99 is some additional general provisions about accessory structures that relate to floor area, and this is to clarify that the total floor area of all accessory structures cannot exceed the principal structure on the property. And then number 106 relates to setbacks on non-conforming lots, and there are provisions in the code now that direct you how to treat setbacks for dwellings on a non-conforming lot, but it doesn't speak to accessory structures, and so that's led to a lot of questions over the years. So we're adding the same for accessory structures. Moving on, administrative hearings. There's a number of items. These are administrative hearing officer hearings related to zoning, different types of zoning applications. ID 322. We're adding to simplify the requirements for notice of these hearings, and we're proposing just a straight, the AHO notifies property owners within 300 feet of the site of the subject application. Right now, the code includes some language that speaks to confronting and adjoining lots, and it's pretty confusing. Not only our staff, but outside parties really struggle with how to use that language, and we think it will be much simpler for everyone if we just have a straight 300-foot distance requirement for notifications. 323 is just a change to make pre-file meetings be optional instead of mandatory. We find that not all zoning cases really need to come in and meet with us for a pre-file, so we think let's don't require that extra step in the process if everyone doesn't need it. So we would make that optional. 324 is some technical changes that just clarify terminology and when we need to be referring to a sketch plan versus a concept plan. That's a very technical change just to correct some terminology. It also removes the requirement for topography to be field run because these days there's a lot of accurate sources to use for topography. We don't necessarily need to require an applicant to hire a survey to go do field run topography. And then 325 will change the 10-day requirement and will allow a zoning application to be modified up to 21 days before the hearing date instead of the current 10 days, and that's because the 10 days doesn't allow our office sufficient time to send an application back out to all the reviewing agencies to compile those comments, to draft our staff recommendations, and get them to the hearing officer in order to meet the posting date. So this is really a technicality that the 10 days is not really workable if someone wants to modify their application.
Ms. Miller?
Yes.
So as we go through these, could you, for the public to have out, most of these, are these changes that I know y'all have been tracking for a long time of things that need to clear up? Sure. Are these primarily changes that are come about because of legislation we've passed or the state has that we need to update, or these things, like you said, that common practices, we're doing it this way, so should change the code to reflect that?
I would say it's both. A lot of it is just, as we always say, the zoning code's a living document. As we continue to work with it and outside parties work with it, we find certain provisions that just don't work as well as everyone thought they would when they were initially put in the code. So we're constantly making adjustments to those. Some of them may relate to more recent legislation. I can think of a couple, but most of it is just based on continual, regular, yearly use with the code and finding things and having things pointed out by constituents, engineers, and developers that over time we've all sort of collectively decided they're just not working that well or they're not clear.
They're not the most efficient or transparent to get things done, and that
Right.
clarifying it would make everything run a little bit more smoothly.
Yes, I think that's a good way to describe a lot of this.
Okay. Mr. Smith.
I was just going to say, appreciate, I know last month we had our sit down with your team and to talk about all these proposed changes. And so it was definitely a thorough, spreadsheets that were attached that were very extensive. And so just appreciate that education going through all these items.
Sure.
So, thank you.
Have you, I mean, there's so many on this list. I mean, it's quite impressive how much time and effort's put in this. Are there some particular provisions that you think might be more controversial, that maybe that you got that there's some disagreements? I know you got a lot of comments and you made a lot of changes, but you didn't make all the changes people put in. So are there some things that we are anticipating might be more concerning?
I will try to pull up a few and then I'll ask my colleagues if they want to add on. Let's see. This is actually the next item I was going to get to, but I'll point it out. There's some conditional use requirements in the code that relate to community-based assisted living facilities, group homes, and rooming houses. And it was a provision put in the code that prohibits these uses from locating on two adjoining lots when they're under the same ownership. And I believe that was added to the code with the rationale that somebody was trying to prevent a conglomeration of these uses all clustered together. Nevertheless, the legal opinion is that that type of condition is challengeable because it is not consistent with fair housing laws. So we are proposing to remove that. So that covers a number of items. We're changing those items from conditional to permitted, and we're proposing to remove that condition. Whether that will, it's difficult for me to always say what people are going to come out and
Right.
want to discuss and what they're not. Some people may have questions about that because I take it that some people had pursued the council previously to have that condition added. So that's one.
Right. As you know, things that we think might be controversial often aren't, and things we never anticipated blow up. So you're exactly right.
Exactly.
We don't know.
Yeah, we have that same experience.
Ms. Fiedler.
Thank you, Madam Chair. Are we at the point for questions?
Yes, I mean, I'm going to, as we go along to pull in, I'm just,
Okay.
so we don't forget. So yes, things come up. Right.
Well, I think you may have mentioned it, or you were talking and I was reading it, so I thought you mentioned it. But crematoriums are being added as a definition to the code. Since we don't have them as a definition, how are they currently locating in the county? And are we changing where they can be located in this bill? And I'm asking because there is a crematory in my district that it's kind of close to a residential community. So I'm just very aware of this area.
I believe we've allowed them to date as accessory to a funeral home. Is that correct? But our understanding is that there is a need or desire on some of these parts to be able to allow them as a standalone use, not necessarily accessory to a funeral home. So that's why we're proposing to add the crematory as its own principal use in itself, and then also to define a second use that would be a crematory accessory to a funeral home, so that we're covering both bases.
Okay, and I just want to make sure, I'm trying to toggle between the shared drive, your document, the chart, my questions.
I know.
Funeral homes are allowed in the same zoning districts that the bill is proposing crematoriums be allowed in, to the same degree, whether it be permitted, conditional.
Let's see, the bill is proposing to allow a crematory as a conditional use in C4, W2, and W3. So sort of the heavier commercial and industrial zones. And then it's proposing to allow a crematory accessory to a funeral home as a conditional use in C2 and C3.
Okay, so if I wanted to see where funeral homes currently are allowed, that is where crematoriums are currently allowed too, as accessory. That's what I'm trying to figure out. If we're changing anywhere that crematoriums can be versus where they can be now as an accessory.
Okay, and it looks like we're checking that to confirm where I think funeral homes are allowed.
And if you want, you don't have to answer me. I don't know if it is better, because this is such a large bill, if it's better to gather the questions and then if you don't know here on the spot, come back to us. Because I do have other ones. I don't know if my colleagues have questions ready, but I have a whole list.
Yeah, whatever works for that. We're here to answer your questions now, and if you have others that you can't get to today, or that you just send them to us, and we'll compile answers for you.
I personally don't have it. I mean, I say go ahead and ask them, and but y'all feel free to say we will get back to you on that one. But just so that it's on everybody's radar of what's coming through. So
Yeah, and anything that I ask, I think certainly should be mentioned that there is an answer during the public hearing on the bill in the future. Transitional housing facilities. This is actually a topic that came up recently in my district. What is the definition of a transitional housing facility, and are they a protected class of housing at the federal level?
They are. I'm going to refer to the bill actually, because we have a proposed definition in the chart, and then I think we changed it slightly in the bill because we wanted to add a statement that these include support services. So the operator of the transitional housing provides some level of support services. So I'm going to find that.
It's page 27 of the chart? No. Oh, sorry.
Yes, it's a residential facility that provides temporary, intermediate term housing with or without food and programmatic support services to individuals without permanent housing, but does not include temporary shelter in periods of extreme heat or cold or during state of emergency. And that actually, that there is a definition in the code now for transitional housing, but we're amending it.
Okay. Do we know if transitional housing is a protected class?
Kelly County Supervising County Attorney. No, not standing alone on its face, because it doesn't. It's not defined to house people with disabilities or things of that nature. Right. So those people would be in a protected class if it were like a group home and things like that. Those are protected class. But these, even though they may have those, co-occurring conditions, I don't think by itself it would fall into a protected class.
Okay, perfect. That answers that question. May I continue, Madam Chair?
Sure. Go ahead.
Page 13 of the chart that was sent to us, swimming pools private. I just want to confirm that by removing that definition from the code, or used from the code, and the feet that are required for private clubs, that we're not creating any non-conforming uses for existing private community pools. I think it's a requirement of 50 feet from a residential lot. I would assume we've gone out and made sure that all of those pools are 50 feet.
No, Ms. Fiedler, we have not gone out and made sure the whole pools are 50 feet. Do you want to speak to that, Sterling?
Sterling Say, Zoning Administration, OPZ. The way the use chart is set up, it allows private pools as a principal use on a property with no other use. It will not affect homeowners associations, backyard pools. We're just removing it as a principal use, as a set-alone use on a residential property.
So in the circumstance that you have a community pool, I believe that they will fall into the private clubs. I don't have the use chart in front of me. That would be helpful. Right above private swimming pools in the use chart is the category that they would, I presume, fall under.
No, this would allow, the way it's written, the use chart is a principal uses of property. So it's allowed, if you had a property, you could just put a private swimming pool with no other uses. Generally, they are accessory allowed, and it doesn't affect them. It's accessory to a house, to a homeowners association, to a country club, any of those. So it's just to say that nobody could buy a lot and just put a private pool as a principal use of a residential lot.
So what does that mean for private pools that are on residential lots in community that are only serving as pools?
Those would be considered accessory to swimming pools, to the residential use.
The larger residential
Yes.
use, not the residential use on the property.
Correct.
Okay, that clarifies that. Thank you.
So you couldn't just buy a random lot and put a pool there without a house or anything and not an HOA just because you have a property and you want a pool?
That's what we're trying to avoid.
Okay.
Okay. I think this goes to interpretation, right? I was interpreting it a little differently as primary with a residential structure as that individual lot, not the entire surrounding area.
Right.
Okay.
This allows it as a principal use without any other uses on the lot.
Okay. That's very helpful. Thank you. There are several pages that amend the marina section of our code, adding business complexes on page 19 of the chart. Page 20, lines 1 through 4, adds a few new provisions, definitions. I have learned this through introducing marina type legislation. Have we run all of these changes by, or is the commission weighed in on these proposed changes? The marina, I forget their official name off the top of my head.
I'm sorry, have we run them by who?
The Maritime
The Cruise Liner
Commission.
Commission.
Yes, thank you very much.
Oh, no, we haven't,
Okay.
but we can do that.
I think that we should, because what I thought was simple pier lighting turned out not to be so simple, and I had to withdraw.
Right.
There is on page 22, adding the potential for grocery stores in the small business district. Understanding that in the small business zone, there's supposed to be a residential look to the property or to the structure. How does that marry with a grocery store? Because if it's something that is, if it's a grocer type business that is going into a structure that looks like a residential house, I would see that more as a convenience store, which I believe is already allowed in the small business zoning district. Grocery store to me is big box, lots of stuff. Would the administration support not adding that to small business?
We can certainly discuss it, Ms. Fiedler. We did struggle with this, and I would say while it's common for grocery stores, especially these days, to be quite large, there are still small grocers out there, and I think we ran into a case where someone wanted to operate sort of a smaller local grocery store in an SB district that didn't really seem to, it seemed to be beyond a convenience store, something in between a convenience store and a large grocer. So we can think about whether there's a better way to address that need.
Okay, I don't know the specifics of that situation, so if we can talk offline and I can understand exactly what they were looking to do and how the small business zone prevented them from doing that, I'm certainly open to more discussion. I mean, go out to a little town in Ohio, Granville, Ohio, and there is a grocer that is located in something that looks like a very large home, and it's wonderful and it has a small town feel. So I don't want to prohibit that type of business, but grocery store does conjure up the image of a big box, and I just want to make sure we're moving forward in the right way for the small business.
All right. I do believe there's also some provisions in Article 17, and I don't have that in front of me, that relate to the small district that speak to using architectural features or design features that would serve to make the use more compatible in a small business district. So that's there as well, which can sometimes help.
Okay, I'll take a look at that and maybe we can have a longer conversation. Maybe there's a maximum square footage or something that we can put in there. But I appreciate that feedback, and I only have one more question. Page 24 in the chart that was shared with us, the food trucks and where they can be located. I noticed that it said like HOA property, private property. Can food trucks not be parked on a county roadway under the proposed change to county code? Because that's where I see them parked for, a few hours for one evening. The community will organize that.
Sterling say. Food trucks can be parked on the, zoning doesn't regulate the public roadways. So yes, they could be parked. The police permit them to.
Okay.
We regulate private property. And so this is affecting private homeowner associations, private clubs, things like that.
Perfect. And I appreciate that clarification. I mean, even doing this for as long as some of us have been doing this, you sometimes forget that caveat. But I know that that's a question that's going to come up because communities across the county have food truck nights, and the county roadway is really important to that success.
No, and I appreciate that change because I have an HOA that has run into this issue over the years, and to have that clarified about for their food truck nights is, thank you. So, all right. Okay. All right. We're going to hand it back to you, Ms. Miller. We kind of jump in. You know how we are. We're going to.
No, please.
As things come up, we
please do.
forget it if we don't ask right when we're doing. So.
Okay, so let's see. I'll go back to the index then. So we were at the bottom of page 1, assisted living facilities. I actually talked about that one. On page 2, attack dog. This we're defining what this is because our understanding is that this type of training of like police canine dogs is typically done at a police facility and shouldn't be done just on private residential property. We did have a case where that was happening, and it was causing a lot of problems.
In all the bills that we've done lately around pet care facilities, have we addressed attack dogs at all, Ms.
I don't
Beach?
believe we have, which
Okay.
is why we wanted to define it. And then the other changes listed here, 52, 53, and 298, are clarifying for the pet care and the pet daycare uses, as well as commercial kennels, that any training that's done in association with those uses would not include training of attack dogs.
Okay.
Next, bed and breakfast inns. This is bed and breakfast homes and inns, pretty straightforward. We're defining each. And currently now they each have a conditional use requirement, and there's a map in the zoning code that limits these uses to only, in general, waterfront communities in the southern part of the county. And our thought is that we should allow B&B homes and inns beyond just those specific communities. So we're proposing to remove that limiting condition. Next is contractor shops and yards. This change relates to both a need to try to find a way to allow this use more widely, but also to address, we have a lot of zoning violations and complaints related to this particular use. So what we're trying to do here is, instead of having the one definition and type of use that we have in the code now, we've tried to create two different uses, a limited contractor and a general contractor. The latter would be the little bit more heavier type of contractor use. And we're proposing to allow the limited contractor as a conditional use in C2, C3, and W1, which are sort of the less intense zones, and then to allow it as a permitted use in C4, W2, and W3. And then the general contractor would be allowed just as a permitted use in C4, W2, and W3. Again, the more intense zones. And the main distinction between the two really relates to outside storage. So for the limited contractor, we're proposing to limit outside storage to the way that it's limited now in the underlying zoning districts. But so for in a residential zone, that limits it to 15% of your coverage. And then for the general contractor, we would not have those same types of limitations. So we would envision a contractor use that has a lot of piles of materials, concrete stuff stored outside. That would fall under a general contractor, and it would be permitted, but only in the heavier C4, W2, and W3 zones. So we're hoping this will provide more flexibility for some of those smaller contractor businesses, but that will also help us address the many violation complaints that we get related to contractors, primarily when they're located illegally in residential districts. So, questions on that one?
Yes, ma'am.
I didn't know if you saw my light.
I'm sorry. Yeah.
I just wanted to ask, that particular change may have an impact on a particular set of parcels, property that's in the Region 6 comprehensive rezoning. And I'm curious if you're familiar with that and whether that, first off, are you familiar with the property that I'm talking about? It's on General's Highway.
I'm not sure which one.
I'm broadly familiar with it, but I see what you're going to ask probably.
Yeah, because this change hasn't happened yet, the property owner is requesting a zoning change for C4. But I don't know that would be necessary. I think that they might be able to meet, their business might be able to operate as a conforming. Do you say conformance or conformity, brought into conformity or brought into conformance? Are those words? And if so, which is the correct one?
Either one works.
Okay, good. Brought into conformance under C3 with the change. I guess that's just, it's kind of like a really unfortunate timing thing with this, for this particular property owner, that they're non-conforming, and obviously it's better for them for lots of reasons for them to be conforming, but we're trying to figure out if C4 is necessary, and of course all of my colleagues would have to support this to get them, so there's a couple moving parts to try and figure out what to do, like how to, what the best path forward is.
Okay. We'll look into that.
Okay. I mean, my path of least resistance is currently to bring an amendment to request the C4 zoning, because that would bring them into conformity under current law, but if it might not actually be needed. And I know that the neighbors would prefer, not having the intense uses of C4 be allowed if that's not necessary. So I know,
Sure.
and this is, I think, the exact reason that you're making this change in Article 18.
Sure. Okay. We will look at, and you said that's the one on Generals?
Yeah.
Okay.
It's just south of, Harold Harbor Road, on the opposite side of General's Highway from Harold Harbor Road, just below the Crownsville Automotive Station.
Okay.
It's like a gas station and repair shop, Crownsville. I think it's Crownsville Automotive is the name of it.
Okay.
Thank you. I'm glad I heard that before I had to leave.
Okay. Let's see. We've got on page 2, country clubs, private clubs, service organizations. This is sort of a technical change to remove the reference to nonprofit and charitable. And we're doing this in several of the use charts that's listed there in the index, as well as in the conditional use requirements. And this is because in the zoning world, the term nonprofit is not really a use in itself. It's a sort of a tax status or an operational status, and there's many nonprofit types of or uses that are commonly nonprofits that are found elsewhere in the use chart under the specific use that they are. So just over this years, this has caused a little bit of confusion and complication in applying the code. So we're suggesting to take that out. Let's see, on page 3, crematories, we've already discussed. Under that is the topic of density, where this is fairly straightforward. We're just adding what is our current practice, is that certain types of dwellings, which mainly is ADUs, farm tenant houses, and caretaker dwellings, don't count towards density when you're doing a density calculation in the code unless they're in the critical area. So we just want to clarify that. And then also under density, the RA density bulk regulation, we're just tweaking the language to clarify how that should be applied. We had initially had that in the public review version of our matrix. We were going to remove that, what some people call the bonus density part of it, because that was recommended in Plan 2040. But based on further discussions since then, we determined that that might have a negative impact on the valuation of ag preservation easements, and no one wanted that to happen. So we're going to leave the additional it's not really a bonus, but people tend to call it a bonus density. We're going to leave it as is. Okay, under that, we've got enforcement, number 327. This relates to unregistered vehicles. This change is really to clarify how we're going to treat the storage of vehicles outside, and this is being done mainly for auto repair businesses, which obviously need to, they can't always store all the vehicles that they're working on inside. They have vehicles parked outside. And we've gotten over the years a number of complaints and alleged violations that this was a zoning code violation. And the way it can be the way the code's written now, but we feel like we need to allow auto repair businesses to have vehicles stored outside. So we're suggesting that these vehicles can be stored outside for up to 90 days if they're being worked on by an auto repair shop, so that all these auto repairs won't be code violations. 328 is addressing oversized vehicles. This is really just a technical amendment. We took the definition of recreational vehicle and we moved it up into Title I to create a specific definition for that use. So that's why we're changing it in Title 16. 329 relates to portable storage containers, which are generally prohibited on residential properties, and we're proposing to change that language to allow them in conjunction with a farming operation, because we have heard, excuse me, from property owners in the RA district that operate farms that they do sometimes have a need to use these portable storage containers in relation to their farming operations. 330 relates to recreational vehicles. We're just putting a very clear statement in the code that RVs cannot be used as a dwelling unit. That's another item that we frequently get complaints from people that their neighbors have an RV in the back and people are living in it. 331 is sort of a technical change to the code. Spells out the process and says that OPZ issues administrative orders, which we do not in fact do. When there's an alleged code violation, we inspect the property, we issue a notice of violation, we re-inspect. If it's not cleaned up, we issue citations, et cetera, et cetera. It might lead to an injunction, but nowhere in that process do we issue anything called an administrative order. So we're just removing that from the code. Facility, this is a pretty minor thing. We're defining this term to distinguish it from a structure, because those two terms seem to be used sort of interchangeably in the code. And there's a number of places where structure is really the correct term to use, or facility may be. For example, if you're applying setbacks really need to be applied to a structure. So we're just trying to clean up that discrepancy, and all the ID numbers listed below that are the places in the conditional use title where we're either changing it from structure to facility or vice versa to make the code more correctly applicable. Food trucks, I believe we talked about already. We're defining it, adding it as a new use. In some zones, we're proposing it be conditional, and other zones, we're proposing it be permitted. The conditional use that we've added, which would apply in the residential, the mixed use, the community marina, and the SB districts, includes conditions that relate, that imposes some limits on the days and the hours of operation, that it be on an HOA or church or school property, in mixed use zones, that it be separated from residential uses by 100 feet, and that in the open space district, that it be accessory to an active rec use. Home occupations, we're adding a definition, and there's a few, these are all lumped under one ID number, but there's a few changes here that are mainly adding a few new business types to the list of allowed home occupations. It's also adding some language because a pet care business is allowed as a home occupation, but there's also provisions in the code that say a home occupation has to be entirely within the home, and we think that's not practical for a pet care business because you may need to let the pets outside, so we're addressing that. And then it also removes the limitation that's in the code now that says goods that are sold in a home occupation have to be produced on the premises, because we're recognizing that there are a lot of businesses that do what we call direct sale product distribution, which we've also now defined in Title I. That doesn't necessarily mean you produce the product on the site. It may just be like an internet type of sales platform, and we want to allow that as a home occupation. So these are sort of changes to allow those types of uses in home occupation. Lots on more than one district. 102, we're just removing that and we're replacing it with the language in ID 113, which basically this is being done to clarify how bulk regulations should be applied in a situation where you have a split zone property, because the way it's addressed in the code is not working practically. So for example, setbacks and heights and things like that, it's okay to apply them based on whatever the majority zoning is on the property. But when you get to things like FAR, floor area ratio, and coverage and density, those really need to be calculated for each zoning district on the split zone property. So this language is clarifying that. Manufacturing. We have just simplified the definition, or simplified the use in the use chart by putting more detail into the definition that's in Title I, and then changing it accordingly in the use chart. This was being done primarily because some questions have come up over the last few years about whether manufacturing includes the actual packaging of the products, or whether it also includes warehousing and distribution of the products that are being manufactured. So we just wanted to expand on that definition to make sure that it works for the totality of types of manufacturing that we want it to. Okay, maximum height limits related to environmental site design. This is a pretty straightforward change, but it shows up in about eight or so different line items, so you'll see it multiple times. But currently the code, when you get to bulk regulations and height limitations in the commercial and industrial districts, it allows for some additional height if setbacks are increased, and also if the developer is providing stormwater management based on environmental site design. We think this is we actually rarely can find a situation where this is used, And the stormwater regulations have changed statewide even, so that environmental site design now is sort of a blanket requirement. It's required to be used, the code says, to the maximum extent practical. So every developer has to incorporate environmental site design. So we don't think it's necessary to include that. So long story short, we're still allowing these increased height limitations based on or associated with increased setbacks, but we're just removing the ESD part because it's not necessary. Moving on to page 5, mobile homes. This is a change that relates to state law that was recently passed, I believe, last year, that currently we require mobile homes on residential properties to be part of a mobile home park, except for, I think, one very limited situation. But the state law requires that the locals now have to allow these as an individual standalone dwelling unit. So we're making that adjustment by an ID 139. We're adding mobile homes outside of a mobile home park as a standalone use. We're proposing it be a conditional use in the RA through R5 districts, which is what the state law is essentially mandating. And the conditions that we're adding in ID 277 are those that come from the state code. And they relate to the fact that it needs to be on a permanent foundation, it needs to have utility connections, the mobile home and the land have to be under same ownership, etc. Okay, non-conforming uses. Number 312 is just a scope statement we're adding to clarify that this section applies to registered non-conforming uses. And then items 313 through 318 relate to the registration, but these, let's see, the first one clarifies that non-conforming single-family dwellings are not required to register. That's been a long-standing practice in the code because there's so many of them. The next one requires that OPC send notice of non-conforming applications to affected property owners. This is not codified, but it's a current practice anyway, so we just decided to put it in the code. The next one increases the rebuttable presumption from 10 years to 20 years. The next one is not really changing any of the standards that are used in making a non-conforming determination, but we think it summarizes them more clearly and puts them all together so that it's easier for the user to see clearly what the standards are. And then last, we're adding a statement that clarifies, again, current practice. I think that non-conforming denials can't be reconsidered again. And then IDs 319 through 321 are adding, what are these doing? These are adding language related to setbacks for non-conforming single-family dwellings in certain situations like non-residential zones. And provides for setbacks for accessory structures. Okay, so the code already addresses setbacks for non-conforming single-family dwellings, but it's silent on accessory structures that might be associated with those dwellings. So we're adding that language in just for completeness. Okay, outside storage, we're adding a definition to try to make it clear exactly what that does encompass. That's in ID 46. We're also doing this to try to distinguish that from a parking lot or accessory parking because, again, we do sometimes get complaints about a property that has vehicles stored on it, and we didn't have an easy way to really treat that in the code, and sometimes it seems to get considered as outside storage. We really see that as something different, and so in relation to this is why in this bill we're proposing to define parking lot. We also have a definition for oversized vehicle parking lot. We have a definition for outside storage, and we're trying to address these things distinctly to make it clear how we feel that they should be treated. And then in the residential use chart, we are moving the allowance for outside storage in residential districts. We're putting it in the use chart. Sorry, I'm losing track here. But the allowance is that it's lesser, it's a lesser of 10% of the allowed coverage or 500 square feet. I'm sorry, that's in an opening paragraph in the residential title. We're moving it to the use chart so that it's more visible and people see that it's there and it's not missed.
Madam Chair.
Yes.
I don't know if this is the appropriate time for this question, and I apologize. I thought we were jumping into questions before. I didn't mean to cut you off or get ahead of us.
It's no problem.
Yeah, so outside storage, vehicles, zoning enforcement, just in that realm. So there's a case in my district where residents have complained about the outside storage of a vehicle that is tagged and titled, but the windshield is covered with stuff on the outside, like mold, and just you couldn't drive it. And all 4 tires have been flat for some time. However, it's not considered a violation because the owner says that it's operable. I'm trying to understand how looking at a vehicle that has 4 flat tires and clearly you could not see out of the windshield if you tried to drive it is considered operable, thereby not enforceable. Would any of what is proposed address that?
I don't believe it would, but I'll look to see if Ms. Kenny wants to speak to that because I know she deals with these enforcement cases a lot.
Kelly County Supervising County Attorney. There's nothing in the rewrite that would really address that. There is the provision already in the enforcement section that requires the vehicle not only to be tagged, but also to be operable, as you're indicating. I'm not sure if zoning enforcement has looked at this. I'm not sure whether it's something that I can ask them about again or get some background on it, because that does sound like it could be in an operable vehicle.
Yes, and it's something I've had staff look into as a potential piece of legislation. I think that this might be the perfect place for it because I guess the verbal response from the property owner was that, oh, it works. So then it was not a violation. So we can obviously discuss offline, but to me, that is not an operable vehicle.
Yeah. And my understanding, I'll say, because I've had an issue in one of my neighborhoods, and traffic enforcement from the police department said if the tires are flat, they consider it inoperable and they will ticket and deal with it if the tires can't be flat. The registration has to be up to date, and But,
and I think staff even looked at other jurisdictions and what if they define operable or not. We can send. Yeah, I have it. We can send you everything that. Well, thank you. Of course.
Okay, let's see. So I think we just talked a little bit about oversized vehicle parking as well. We're just adding this to distinguish it from other parking lots. Parking requirements. I won't go through each of these in details, but these are amendments to the parking requirements section of the code for uses where the current requirements there haven't really been that easy to apply, or they don't seem to be working well for the majority of the uses that they would like to.
Looking at these, are we decreasing the parking requirements or increasing them?
I'm not sure that we're doing either. I think we're
just clarifying,
making clear how they should be addressed. I think I would have to look at each one individually to answer that question. So
I was just asking in general, right?
Let's see what else is in here. And then that also includes ID number 122 is more for clarification because there's language in the code now that relates to allowing for reduced parking requirements for workforce housing, and so we're not changing that requirement, but we're clarifying the language on that one. Pawn shops, The proposal is to change this from a special exception use in C4 to a permitted use. We're not sure why this use really needs to go to the hearing officer to be approved. We're proposing to allow it in C3 as well as C4. Right now, it's just allowed in C4. So we would be removing the special exception requirements for that use. Pet care, business pet, this is a lot of fairly technical stuff, I think, where we're changing the term from dog to pet so that this use encompasses not just dogs, but also cats and other animals that people have as pets. Pets, livestock, and fowl listed under that. This is, again, sort of technical, just removing the requirement that fowl have to be domestic. And it also clarifies something about accessory structures that relate to livestock and fowl. Need to be 50 feet setback from all lot lines. Also allows this in some additional zoning districts like mixed-use zones. Let's see, retail, specialty stores and shops. This is amending the way that this use is listed in a number of different use charts. Really, it's shortening it. Instead of trying to list every single type of use that could fall under this category, which is literally hundreds of uses, we're just shortening the definition and the way it's listed in the charts. Okay, next is single-family detached dwellings existing. So we're adding this to the code to distinguish it from new single-family dwellings because right now existing single-family dwellings are allowed to remain in all districts. We don't require non-conforming for them because it's so widespread. It's not really practical to require non-conforming registration for all of them. But there are certain higher zoning, residential zoning districts, specifically R10, R15, R22, where we don't really want to allow new single-family dwellings. We want, townhome and multifamily and other more appropriate residential uses in those zoning districts. So this is being added to allow that existing single-family dwellings could remain in these zoning districts, but you cannot propose a new development of, say, single-family detached dwellings in an R15 district. State licensed medical clinics. So we're adding a definition that is in accordance with the state code definition of this. We're making a change to the parking requirements to match the parking requirements for a medical office because we see this as a similar use. And then we're changing it from a conditional to a permitted use in the commercial and industrial districts and removing the 1,000-foot separation district requirement that's in the code now for this use. Suburban Community Center, this is pretty straightforward. This is addressed in a bill that's about 20 years old, Bill 3696, and we're taking the provisions from that and adding to the code just to make it easier to use so that people don't have to keep going back and locating Bill 3626 and applying it. So it doesn't make any changes to what that bill allowed, but it's just putting those provisions for special uses into the code.
Would that be like an HOA or I'm trying to think suburban community center?
No, it's a type of use. What is a suburban?
Oh, okay.
The development of Waugh Chapel. So it's zoned R1, but it allows these multiple commercial and industrial uses based on the bill that was introduced in 96.
Okay, transitional housing facility. This is a new use that we are suggesting a definition for, excuse me, to add it to the code. None of the uses that are in the code now really specifically cover this type of use well. So we've defined it. We, in line item 121, we're adding parking requirements. We're suggesting that it be a conditional use in the residential zoning districts and then a permitted use in the commercial zoning districts. And in the residential districts where we're suggesting it be conditional, the conditional use requirement would be one that would limit the number of beds in relation to the size of the property. And it would start with a 2-acre property size minimum and then go up from there.
Madam Chair.
Yes.
So what is the number of beds, if you could help me out, between the 2 or 3 sheets?
Yes, I'm going to have to look up the ID number.
And the reason that I am asking this is, and I don't even know if the concern in my district is indeed for transitional housing or if it is a protected class. There's a little confusion going on about what is being proposed. But the community in which the concern has been brought up is a low-density residential neighborhood that has homes in close proximity to one another despite being low density. So they are concerned with the potential volume of folks coming in and out, how that would work with existing neighbors. So I'll let you answer the question though.
Sure, understood. So what we're proposing is that the facility has to be located on a lot of at least 2 acres, and then an additional acre for each group of 25 beds or fraction of 25 beds in excess of 40. So in other words, the blanket allowance would be for 40 beds on a property of at least 2 acres. And then if you want to increase that number of 40, each incremental increase of 25 beds would require an additional acre. I hope I said that right, did I?
Okay.
That's the proposal.
Okay. I might be proposing an amendment if the bill is introduced like that, just because of the concern that has come to my desk. Even if it ends up not being a transitional housing proposal, I think that the concern still exists should it be proposed somewhere else in a similar kind of community with the larger lots, but there's still a lot of larger lots or a lot of residential homes on those lots in a very close proximity to one another.
Okay, 20-year registered use is the next item. This one we are proposing to remove altogether from the code. The use, the definition, and the allowances that address it, which are primarily in number 318 in your chart. So I recently shared a memo with the council, I believe through Ms. Schultz. So unless you need more information, I'm not going to go through all the detail in that memo now, but we have found this allowance in the code to be much more problematic than we have found it to be helpful, and it basically serves to legalize uses that were never a legal use in the code to start with. So that's distinct from a non-conforming use, which is a use that was allowed in the code at the time it commenced, and then due to later subsequent code changes, it was no longer allowed. So that's a common type of provision found in local zoning codes to allow for non-conforming uses. I don't believe that this 20-year use thing is common at all. We haven't really found examples in other local zoning codes of other people who treat these uses this way. And it's resulted in a number of cases where we've had some fairly intense uses. I'll use contractor yards as one example, or other uses that tend to be impactful and that lead to a lot of zoning complaints. And it has allowed them in some cases where we really don't have any ability to enforce or limit them now because of the way this is constructed in the code. So our suggestion and preference is to remove it altogether, and I don't know if Ms. Say or Ms. Kinney want to add on to that, but we provided a fairly detailed memo to the council about this particular item, and it lists all the uses that, at least as of last summer when we prepared the memo, had been granted this this 20-year use status.
So the ones who've already been granted this, would they be grandfathered and it would just be moving forward?
That's our suggestion. Yeah.
And I did read the memo, but it's been a little while since y'all sent it. I just want to clarify. So for instance, let's say somebody has a not non-conforming, and a never approved use that they're doing it, but they've had it for 20 years. Do we have the provision that when and if the current owners were to pass away or sell the property, then the use is not allowed?
Sterling Say, zoning administration, it's only allowed to transfer to a child of the owner.
Okay.
All right. And these are illegal uses that started, no one complained in the first 20 years of it. And when we register it, and it's usually grown to the point where people are ready to complain.
Right. Things have come about, right? Okay. Thank you.
Okay, we are almost at the end of this. So the next item is zoning certificates of use. ID number 94, that is codifying what's a current practice now, which is that a zoning certificate of use is not issued prior to SDP or site development plan approval if one is required. And it's also not issued if there are outstanding zoning violations on the property. So that's current practice now, but we want that to be codified in the code. ID 95 deals with compliance, and that would codify language that clarifies that a property can't be used for a use that doesn't conform with the zoning certificate of use. So in other words, you can't have a zoning certificate of use allowing one use but use the property for a different use. And then ID 96 relates to right of entry, and this also is just to clarify what is the current practice, which is that OPC has the right to enter and inspect a property for compliance with a ZCU application. And then the last one, I don't think I'll need to go through each of these individually, but we've added zoning, what we call purpose statements for all of the zoning districts in Article 18. These are general descriptive statements. They're pretty commonly found in zoning codes. We used to have them in our code in years back, but they were removed in the 2005 code update. I'm not quite sure why, but I think most people find them helpful, so we're suggesting to put them back in. And they're used to relate the zoning code to land use plans, but they're not regulatory, and they don't supersede the specific code regulations that fall within each title and subtitle. They're more of a just general descriptive statement. So we're proposing to add one for all of the zoning districts.
So we haven't done an update of Article 18 in 20 plus years. What do y'all believe would be a good time frame to do a regular review of the zoning code?
I have seen it done in many different ways, quarterly, annually, biannually. So it depends on the volume of it. I think that in larger jurisdictions, I think that there could be more time allowed during the course of a calendar year to do some of these type of house cleaning kind of things that change if state law changes, then we need to change, and so on and so forth, rather than be reactionary. As you can see by some of the things we've gone through today, it's pretty dry. And they're things that we definitely have been, working with for possibly 21 years, some of them less time. So it would be nice to have it to be in a more regular time frame.
Just thinking if there was legislation put in requiring of a time, what would be a good, what would be a workable time frame to say there would be a periodic review or something like that?
I would talk to my staff here, but I would say at least annually to allow us to have some, take a batch rather than henpeck you with little small things.
Right. I mean, because there's things every year that come up between
Correct.
what we pass and what the state does that have to be, that should be corrected. And sometimes we don't catch them all, but. All right. Anything else from our big crew that we have here today that made it all the way through today? So,
To the chair, I just wanted to add, we do have another work session scheduled in March for this legislation because it's so large. And admittedly, we struggled a little bit with how to best sort of present this in a work session because it's so large. And the idea of trying to go through the matrix that has been online for a while, because there's 332 line items, we were really concerned about how long that would take. So our effort today was to try to group certain topics that appear multiple times within this 332 item list together. So obviously we did not cover every item in this list. We thought we could start by trying to cover items that can be grouped together into a smaller number. So having said that, if you all have suggestions about how we could format the next work session, whether that's, take all the remaining items that we didn't talk about today and cover them, but a lot of those are like single line items. So we're open to suggestions about how you all might want to approach. Again, we do have another work session and we want it to be helpful to the council and everyone else. And just because of the nature of this bill, we've really been struggling with how to sort of present it in a way that's not overwhelming.
Ms. Pickard.
I believe in our briefing, y'all did a good job of talking about the different aspects of the changes, like conforming with state code. I'm just less thinking about our work session and more thinking about how to present in the council meeting when we're at our first public hearing. So to make that relevant to the people watching at home. So that's, I don't know if the way I think there were 6 categories of changes that we discussed, something like that.
Yeah, there were 9. 9 categories, yeah.
Trying to figure out the best way to present it at the table when we're in a public hearing and actually is, I think, going to be key. But before we get to the introduction, I wanted to ask, are y'all currently fielding questions from stakeholders or possible changes before it's introduced? Are y'all entertaining any of that currently? Are you getting direct contact from stakeholders about things that are needing to be either added to what's already here or revised? I'm just curious.
Yeah, I would say we have, other than last fall when we put out a preliminary review draft, we got a fair amount of feedback on that and we made adjustments accordingly and put out the final draft. Since then, we have not gotten a lot of input or questions or comments from stakeholders in general. That we did have a meeting with, I think, some representatives from MBIA and NAOP both, or at least from MBIA, shortly after the comment period had closed, but they had missed a few things in the comment period and they met with us, and we did add a couple of changes between the preliminary review draft and the final draft based on that meeting. But we haven't had a lot of other people either reaching out to us asking us for a dedicated meeting to discuss it. We're open to meeting with anyone who wants to talk about anything in the proposed bill. Happy to do it.
Madam Chair, if I may, the bill has now been filed with the council office. It has been signed by the county exec and has been delivered, so we are working on preparing it for introduction in March.
Oh, so it's baked. It's done. Okay. Good to know.
If they would need to come down with a new draft, it would only delay things further.
No, I'm not asking them to
Okay.
do that. I'm just trying to see where we are in the process. I mean, this is a ton of work. Y'all have done amazing work over the years in collecting all of this. I shared in my briefing that I'm anxious about what this looks like for the council as people coming to us wanting to amend the proposal. So, or now that we're opening up Article 18, are there other stakeholders going to come out and want to address issues that aren't identified here? So I'm just mindful of other large policies that have come before us with hundreds of amendments. I'm hoping that that's not what we're looking at. I guess it would be helpful to know from y'all, as council members are communicated with outside stakeholders, how best it would be to work to see if it's, this is a huge rewrite, and I don't think individual council members are going to be able to know if this change, if it sets off a cascade of a lot of other changes. So I feel like maybe we should communicate a best way to work through potential amendments. It's not like region plans, but there's something, just a way that we can be efficient and effective with any amendments coming forward, if that makes sense. Just thinking about the process.
Yeah, we sent out an email to everybody, I think last week, just still starting to solicit feedback and things like that. If you have maybe one-off questions that you're getting from constituents or something like that, please send them to us, because oftentimes it could be a clarification, actually, and maybe not an amendment, just to explain what it means and how it's applied, if that makes sense. I think that as we continue to go through the next couple of weeks, please still keep contacting us. That's why we wanted to meet with you all well ahead individually, to at least give you a heads up about what this was about. And I'd like to continue that dialogue, definitely.
Ms. Fiedler.
Thank you, Madam Chair. I appreciate the communication as well, and the preview and all of the diagrams. And I completely agree with my colleague on now the challenge is presenting it to the public in a way that they can get through it and navigate it all and have questions. I did not realize that the matrix is out for public review. Is that on? Oh, it is not. Okay. I think if there's any way that
if they put something on if OPZ put something on their website, they did that preliminarily.
It is on the OPZ website. Right?
Okay, perfect.
Correct.
I think if there's any way to give some kind of brief description on how the matrix works, because it gives the numbers, but it took me a few minutes to figure out, okay, what are those numbers referring to? And it's the chart, but it's the public number or the revised number, not the original number. Correct. So I think explaining how to use the information that's available will help folks navigate. I'm not going to say easily, better. We'll just leave it at better. And just so that the public understands the size of this bill for anyone that may be listening at home, I really lowballed you all. I said, 150, 175. No, it starts with a 2. So this is going to be a big, heavy lift, and making sure that we leave no stone unturned and don't leave any unintended consequences. But a lot of these are necessary. I think we're going to agree on a lot of this stuff. It'll just be the nuances of details that we need to probably reconsider.
No, I appreciate today kind of going over in a little more detail on some of these things. I envision, and we'll see, but I envision that our next work session, hopefully all of my colleagues, we will have had more time to look through it and be hearing from people, and we'll be able to come back maybe with some more specific questions, especially on some of those individual items that may have come up. I agree with my colleagues. I think one thing we need to be wary of is I think we will all be hearing from a lot of outside stakeholders with very specific wish list of what they might want to see. And while some may be valid, this shouldn't be just an opportunity for people to get whatever they want that comes through, that this is really us trying to modernize and clean up the code, not, be adding wish list, items for things people have always wanted. Those can be addressed in different ways, but not necessarily in this. And hopefully all of us will work to kind of quell some of the enthusiasm for that when we hear from people from outside to do that. So y'all have anything else you want to say to us? And so Miss Ganley is ready to go with her magnifying glass to go through every little provision and help us out with understanding everything. She looks very happy about that prospect of 200 pages. So, any other comments? Thank y'all so much. This is a massive amount of work, and we look forward to jumping into it.
Thank you for your partnership. We appreciate it.
Yes, and we do appreciate you taking the time to meet with each member beforehand so that we all have, we're getting as much of a foundation as we can before we jump into the actual public part of it to come out. All right. Is there any other business any council member would like to bring before the county council at this time? No. May I have a motion to adjourn? It's on my script, so yes. Do I have a second? All in favor? Aye. Opposed? Motion carries. The county council is adjourned until Tuesday, February 17th, 2026 at 6 p.m. for our next legislative session in our chambers. Thank you.